Item 1 for withdrawal.
Meta में भी pass over for the timing. Machinery vote number 3.
Item 2 for motion.
Met please lords. As per last order, my lord, I was asked to obtain instructions, my
जी,
lord.
doctor.
I have obtained instructions, but she is not in a position to, my lord, deposit this amount, my lord. My lord, WS, my lord, my lord, my lord, my lord, my lord. My lord. I will just make nothing of the recall, my lord. My lord. My lord. My lord. My lord. Deeply blessed.
3 and 4 for hearing.
My lord. Pandit Perus order dated 24/5/2023, my lord. Regarding, my lord, trial by summary court.
Timing করে নেব কপি আছে না তোমার
Respondent, my lord.
এটা কপিও নাই তুমি ফাইল করো
R. Devi, my lord. SSD personnel appeared that, my lord. LS offense, my lord, no, my lord. The LS offense is that, my lord, the petitioner, my lord, fired, my lord, 6 rounds of, my lord, in the ear, my lord.
That's it. After following due procedural laws, if you assist.
No.
Yes.
Read order of 24/5/2023. We have heard you
Yes, sir.
at quite a length on this issue.
Yes.
I know you have followed procedure. But the question is, if it is a serious allegation, why you invoke only section 86? Why not 84? This is the answer we want from you.
Lordship, regarding
86 is a summary proceeding and 84 is a general proceeding. And reading 84, there is no bar that a man of a constable or below cannot be tried by the general court. It's nothing like that, that it is compartmentalized. Constable below, summary, constable and above general. It's nothing like that. General has the power to try every kind of an official from top to bottom. Summary, only constable and below. This man is a constable and below. But when the allegation is serious, why will you not invoke 84?
Lordship, since it is a
And we want the records from you where you have exercised the discretion that this is a fit case for summary and not for a general.
Lordship,
Please produce that order. If you are not produced, we are setting aside. You go back and take the decision.
he was charged for violation of discipline, Lordship. And
I know
Yes.
we are aware of the charges. You don't have to repeat it again.
Yes.
Please, either you answer the question raised or you don't answer. We'll record judicially that you are refusing to answer. But don't say something different. Produce the records where you have taken a decision that in the facts of this case, it is a fit case for summary and not for general. Is Mr. Rakili Chaudhary available?
He was out of session, Lordship.
Sorry.
Earlier he was out of session.
Not
and
today, as on today. We are not asking what earlier.
I have to wait.
Just, well, it's a little question, we want to go into it.
Lordship.
No doubt 86 says constable below can also be tried by a summary court.
Regarding disciplinary matter, Lordship, Commandant has the power to take action against the.
Is firing of arm only disciplinary matter? Or it is mixed with some other matter?
Lordship, as per 86, Lordship, all the.
Then we do one thing.
Certain exception.
Sorry.
Lordship, under section 86, the limit is, Lordship, only if the imprisonment is for 1 year and 3
And
months
what is the punishment imposed now?
dismissal from service.
Ah.
Lordship.
And you say 86 limit is only 1 year imprisonment. Then how can you dismiss?
Summary force court may try any person subject to the under.
Madam Devi, we are constrained to tell you, you are repeating the same thing at least for the last 10 days.
Lordship.
And you are never improving upon your argument, nor you are answering the question raised. You have just adopted the strategy. I repeat the same thing every day. Let the court ask whatever it asks. Let the court think whatever it thinks. I am going to repeat my pre-recorded statements.
Lordship, general force court.
So
An elaborate procedure.
we are
is-
sorry to say,
Lordship.
if you do not respond to the question in proper manner, we may disengage you. Because we are not getting the cooperation from you. And mind you, this is not the first day. If you look at the order sheet, this must be 10th or 12th hearing on the same issue. And every day you take the same stand. And every day we repeat the same questions. How long will you expect us to continue in this way?
Since all the cases cannot be.
That answer was given at least 10 times before. We had refused to accept it. Why are you repeating it again?
It's a clear case, Lordship, since he has admitted it. and
Again-
all the evidence is against him.
Same answer every day. Okay, then we allow this petition. No other way out. And we'll observe why we're allowing it for not getting the cooperation on the answer.
Lordship, as per
That
the-
will be a little slur on your career also. Please cooperate. Please Please cooperate. We are giving you, repeatedly requesting you. And the only approach you have taken is no. Come what may, I'm going to repeat the same sentences every day. Why should you accept it once having refused it? And your officer is also same. That Chakraborty or some one man comes, he is also same. And this is a serious question. Summary court is always a truncated proceeding. General force court is always a more elaborate proceeding. When the charges are serious, involving some criminal offense, firing a
And the-
6 round through a firing arm is also a criminal offense, not just a matter of discipline. Why will it be tried only by a summary court? Can we adopt a procedure that all matters of this territorial army or whatever it is, Sima Sasastra Bal,
Yeah.
we will deal it only in a summary manner? We'll only hear the petitioner, yes, what is about. We'll just ask you one question, what is about, decide it. Will you be happy? Let us do that same thing. If you are following for your officers, let the writ court also follow it for your organization. Same way. No questions asked, nothing. Summary. Summary is normally for a very, very lesser offenses, lesser misconducts, which does not require an elaborate hearing. And normally it is for the constable and below, because people of this rank are little indisciplined here and there. So to avoid a more detailed procedure, you have put in this provision that for this category of people where they are involved in some lesser offenses, lesser misconducts, do it in a summary manner. Just because this power is available, will you also invoke it in case of a serious offense, serious allegation? We are not getting this answer. And we have no intention to adjourn it again today. At least 10 or 12 occasions it was adjourned on the same question. So what is the way out for you? First way out is we disengage the learned counsel, ask somebody else to come and appear. Second way out is we believe we have no answer, we allow this writ petition. That will again be not proper thing to do. Third is we call your highest officer to come and answer the court. Let him personally remain present, because your lower officers and the council is not responding. We also put a specific query on the last occasion, produce the records where you have passed an order to exercise this discretion, put it in a summary court and not in a general court. You are not even producing those records. What to do with you now? Or you want an adjournment for more than a month? Let the problem be over forever. Are you thinking in that terms?
That's good.
See, this hearing is going on since when? On the same question. 3/1/2023.
That's it.
How many months have gone by? You were not responding. So we let your Director General remain present, or whoever is the topmost.
That's it.
Let him remain present. No, we have no other way out.
One last maybe given.
No,
that's it.
last chance was given on several occasions, and last word also has its own meaning. It's not an,
Because they're following the procedure of law, Lordship, they have.
you're repeating.
Yes, Lordship.
I know for summary procedure, you have followed the procedure. We are not on that. We never said that you have not followed the procedure. We are asking you a very fundamental basic question.
Because in all the disciplinary cases, Lordship.
Uh,
it's not-
We are passing the order for who is the topmost officer? Who is in charge of this? Let him remain present.
Okay. One more chance, maybe even.
No,
after
sorry,
the
we're,
Lordship, they're on merit.
We are rejecting it.
It may be ordinary.
Either you answer the question raised, or we are asking him, the topmost officer, to get the answer from him. Everything has a limit of its own. Can't play around with the court in this manner. And our question is very specific. When two powers are available, you have a discretion, then you have to give a reason why you're exercising the truncated power and not the elaborate power.
There is no specific law order regarding respective.
We have already passed.
Okay. Therefore,
What's the name of your top officer?
that's it.
Or you're asking the Secretary, Minister of Defense to come if you don't answer that question.
That's why I will try to
No,
get it.
please give the name, let him remain personally present. Sorry, we are,
Maybe on Lordship Thursday, I will try to.
no,
get the answer
you
to
have
the
tried enough
Lordship.
and but you are not responding. We don't want your trial anymore.
Thursday, Lordship.
Every day an unfortunate situation arises in this matter. Every day same thing is happening. Why? Ask Mr. R.K. Chaudhary to come. We are having framed one question, we're bound to answer it now. We can't avoid that. Next to matter.
Item 5,
None appears for the appellant when the matter is called list. उनका ले जाओ. 8 week Friday. In the event of further non-appearance, adverse order shall follow.
item 6.
Mr. S.P. Roy, what is happening? 2007 matter, no one is appearing repeatedly.
Also, they have.
And
completed
outside you will go and say, courts are not doing anything, matters are
They
pending.
have been heard at length.
No, not yours, this matter, earlier matter. It's a 2007 matter.
Oh,
No one is coming.
probably there is no material. in
I
it.
don't know. We have to do our work. This matter,
Yes, Lord.
where is Ali gone?
Lordship, on the last occasion, he was heard at length.
Epilogue your affidavit. Sorry. Third, Mr. S.P. Roy, learned counsel for the appellant. What was the name of the counsel? R. Ali.
Lord.
What was the name of the counsel who appeared? R. Ali.
Other.
Also heard Mr. R. Ali, learned counsel for the respondents. Where is the plaint? Page 25. The appellant Ram Narayan Rajbhar instituted title suit 76 2006 against the respondents Geeta Ghosh, Ashok Ghosh, and Gunu Ghosh. Where? Geeta Ghosh is the wife of deceased Ram Prasad Ghosh, and Ashok Ghosh and Gunu Ghosh respectively are the son and daughter of deceased Ram Prasad Ghosh, late late Ram Prasad Ghosh. We have heard you.
I have filed an affidavit.
We don't need an affidavit, nor we asked you for any affidavit. After hearing is over, there is no scope of affidavit, number one. Number two, second appeal nowhere provides for any affidavit to be filed.
Sir, we don't know what are the margins.
Sorry, will not allow. We have heard you. Hearing is over. After hearing, there is no withdrawal. After the hearing is completed, only thing Mr. Roy have produced one judgment on the last day. We did wait for 1 day for you, whether you want to say something on that. That's all. Not beyond that. In paragraph 3, 4, and 5, respectively, of the plaint, it is stated as extracted. A reading of paragraph 3, 4, and 5 of the plaint makes it discernible that the predecessor in interest of the appellant plaintiff, Durboli Rajbhar, had purchased a plot of land described at Schedule A to the plaint, being land measuring 1 kotha 1 lessa, covered by KP Patta number 25, Dag number 20 of village Fatahil Ambari, Gaon, Moza Beltola, covered by bounded by North Fatahil Ambari Main Road, comma, South Phorolu River, East land of Mr. Das bracket Kalabahar, and West land of Mithailal Koiri and Soap Factory. And the claim is that the land was purchased by registered sale deed 1800/81 dated 2/3/1981, where late Tazmuddin Ali Ahmed is the vendor and late Durboli Rajbhar is the purchaser. Petitioner accordingly instituted the suit for a declaration of right, title, and interest over the Schedule A land, and also for recovery of possession of the Schedule B land, which is stated to be 2 rooms measuring 10 feet into 10 feet, standing over the Schedule A land. Comma, which is stated to have been taken on a monthly rent by late Ram Prasad Ghosh, being the predecessor in interest of the respondent defendants. The defendants filed a written statement taking the stand as stated in paragraphs 4, 5, and 6 of the written statement, which is extracted as below. A reading of the stand taken by the respondent defendants in their written statement makes it discernible that they are in possession of 10 lesas of land covered by Dag number 20 of village Kalapahar Gaon, Moza, Beltola, Guwahati, in the district Kamrup, which, as per paragraph 5 of the statement in the written petition of the written statement, is a government land. Where are the issues framed? Issues framed by the trial sheet.
Issues are lordship, page 17 of the memo appeal.
1-7.
Yes.
1-7 issues are stated. In the circumstance of the readings, comma, the following issues were framed. We particularly take notice of issue number 3, which is whether the plaintiff is the owner and patadar of the Schedule A plot of land, and whether the defendants are in illegal possession. And issue number 4, as to whether the defendants are in illegal possession of the Schedule B land and the house. But what is already noticed is that it is the claim of the appellant plaintiffs that they had purchased the Schedule A land, that the predecessor in interest of the appellant plaintiffs had purchased the Schedule A land from late Ahtamuddin Ahmed as per sale deed number. It was in 1800 something, dated so and so, which apparently pertains to KP Pata number 25, Dag number 20, village Fatahil Ambari Gaon, Moza Beltola, along with a Assam type and Exali thatched house standing thereon, bearing GMC holding number 427 or ward number 19A old stroke 20 new. Full stop. Start how I started the sentence. Is that Omo? Whereas on the other hand, it is the stand of the respondents in their written statement that therein that they own and possess a plot of land measuring 10 lesas of Dag number 20 of village Kalapahar Gaon.
There is no Kalapahar village.
Mr. Roy, they have written it.
No, they have written.
Maybe, please. Of village Kalapahar Gaon, Moza Beltola, and that the land in question is a government land, and that the predecessor in interest of the respondent defendants was in occupation of the land. Clearly, there is a variance on the claim of the petitioner in as much as the petitioner claims ownership and possession over the ownership over 1 kotha 1 lesser of land of KP Patta number 25, Dag number 20 of village Potahil Ambari Gaon, Moza Beltola, whereas the defendants claim ownership and possession over 10 lessers of land of Dag number 20 of village Kalabahar Gaon, which admittedly is a government land, meaning thereby that the appellant plaintiffs are staking their claim over a plot of land, which is a patta land covered by Patta number KP Patta number 25, whereas the defendants are claiming ownership over a plot of land, which is admittedly, as per their written statement, is a government land. In the circumstance, taking note of the variance of the respective claims of the appellant plaintiffs and the respondent defendants, a further issue also ought to have been framed by the learned trial court as to which is the disputed land in title suit. '76 of 2006. Yes, sir. Have you checked up the records? What are the original issues? Please check up. Because what I have only quoted from the appellate order.
Lordship,
Please check
it
up.
was exhibited exhibit 1, original cell deed.
No. You are on something different. Issues.
Issues.
Please take out the original issues framed.
File.
Boro, a record to DD also.
This is the original issue, page 17.
That is quoted in the appellate order. Why don't you check it up with the original one? Because my decision is entirely on issues. Suppose I am wrong. Suppose the appellate court had wrongly quoted, then what will happen? Look. Full stop. If the disputed land is the land claimed by the plaintiffs in their claim, and the defendants claim ownership over another plot of land, which is a government land, the matter could have been decided in a particular manner. And on the other hand, if the disputed land is the government land as claimed by the respondent defendants, and on the other hand, land as claimed by the respondent defendants, the matter could have been decided in another manner. Whereas, on the other hand, if the disputed land is unidentifiable, then the first and foremost would have been a requirement to first identify the disputed land, and find out as to how the disputed land would be described, and thereafter proceed in the matter to decide the respective claims. Full stop. Without framing an issue as to which is the disputed land, in view of the variance of the stand of the appellant plaintiff and the respondent defendants to two different lands, where the claim of the appellant plaintiffs is to a Patta land covered by KP Patta number 25, whereas the claim of the respondent defendants is to a government land as stated in paragraph 5 of the written statement. People. We are of the view that any decision that may have been rendered would be an incomplete decision and full stop. Mr. Roy, where is the other decision rejecting your sale deed? Which paragraph? Rejecting the sale deed, because they said that section 63 or something was not followed. Right,
Lordship may come to page 19.
19.
Para Lordship, they have not serially numbered, but the
Paragraph
second para from the bottom.
page 19. No, this is the appellate court. Where is the decision of the trial court?
Sorry, appellate. In the appellate. Trial court judgment Lordship start from page 68.
68. E8. Is there any such a law? If the defendant does not, if the defendant denies the title, then the original sale deed will have to be proved through the vendor.
No,
Where is that law?
no, Lordship. Original sale deed was proved as exhibit 1 or something. I have
Understand?
taken the original record. And Lordship, relevant portion is page 72. Absolutely perverse finding. From the bottom second paragraph, submission of the original sale deed does not prove its execution when the defendant denies the title intent.
In course of the trial, the petitioner exhibited the registered sale deed, the number so and so as
Exhibit 1.
exhibit 1 to prove their right title and interest over the Schedule A land. The trial court, in its judgment dated 8/3/2010, had decided the issue number 3 as to whether the appellant plaintiffs are the owner of the Schedule A land, had decided as extracted. Having decided the issue number 3 against the appellant plaintiffs, the title suit 76 of 2006 was dismissed. Being aggrieved, the appellant plaintiffs instituted title appeal 45/2010 in the court of the learned civil judge number 3 Kamrup change করে দিয়া তোমার দীঘল আছে আইছে the appellate court had formulated its points for decision by rescheduling the issues frame, where point number 1 for decision was whether the plaintiff has right title and interest over the suit land and whether the defendants are in illegal possession of the Schedule B land. While deciding the point number 1, the appellate court in respect of the exhibit 1 sale deed dated so and so relied upon by the appellant plaintiffs had decided as extracted page 20 মারি দিবা হ্যাঁ Having regard to the aforeextracted portion of the respective judgments of the trial court and the appellate court on the issue as to whether the plaintiffs have right title and interest over the suit A land, it is noticed that both the courts had taken note that discussion বাহিৰ কৰিব কষ্ট এটাকে reason or discussion to the out this বাহিৰ Discussion. please. People.
The respective development plan both in the federal court on the issue as to whether the plaintiff left back at the interest or trustee came in. It is noticed that both the courts have taken note
Taken note that the exhibit one sale deed number so and so dated so and so is relied upon by the appellant plaintiffs to prove their right title and interest over the Schedule A land, which apparently is a land measuring 1 kotha 10 lessers of 1 kotha 10 lessers, 1 lesser, 1 kotha 1 lesser of KP pattern number 25, Dag number 20 of itu চাই লবা আগতে কোৱা আছে and also proceeded on the premises that the defendants have denied the right title and interest of the appellant plaintiffs over the Schedule A land. On the aspect as to whether the right title and interest of the plaintiffs had been denied by the defendants, comma, we refer to paragraphs, the statements made in paragraph 4, 5, and 6 of the written statement. As already noted, in paragraph 4, 5, and 6 of the written statement, it is the clear stand of the defendant that they are the owner and possessor of a plot of land measuring 10 lessers covered by Dag number 20 of village Kalapahar Gaon, which according to the defendants is a government land. No statement is discernible in the written statement that there is any denial in respect of the claim of the appellant plaintiffs that they have right title and interest over the land measuring 1 kotha 1 lesser of KP pattern number 25, Dag number 20 of so and so. In the absence of any determination as to whether the disputed land is the land measuring iman of KP pattern iman, to repeat the land measuring 1 kotha 1 lesser of KP pattern 25 ... or whether it is the land covered by pattern number 20 of or it is the land comprising of 10 lessers of government land
Tag number 20, not
of, please don't disturb. Please don't disturb.
just
Mr. Any correction, you can do it at the end of the order.
tag number 20.
Mr. SP Roy, any correction can be done at the end of the order. In between, please don't disturb. Because the thing goes away. Next time you do, we are going to adjourn it straight away. It takes a lot of difficulty.
on whether it's the land covered by Dag number 20 or it is the land comprising of 10 lessers of government.
Of government land of Dag number 20 of village Kalapahar Gaon.
The absence of any determination.
A disputed land is the land measuring so and so, or it is the,
Whether it is the land covered by Dag number.
or whether it is the covered by Dag number so and so, comma, and in the backdrop of the stand of the respondent defendants in the written statement that that they have ownership and possession over 10 lessees of land, which is a government land of Dag number 20 of Kalapahar so-and-so Gaon, comma, even the proposition of implied denial is found to be absent in the present proceeding. Full stop. In view of such conclusion, both the trial court as well as the appellate court had proceeded on an incorrect premises that the claim of right title and interest of the appellant plaintiffs over the one kotha, one lesser land of KP Patan number 25, Dag number 20 of Ambari Gibagibi ase, had been denied by the respondent defendants is found to be contrary and incorrect to the stand of the respondent defendants. Next paragraph. When the denial of the appellant plaintiffs over their right title and interest of the Schedule A land, which is over one kotha, one lesser of KP number equal to
And the denial of the appellant plaintiff or their right to claim interest in the Schedule A land
is found to be absent. The proposition sought to be decided by the trial court as well as the appellate court that in view of the denial of the right title and interest of the plaintiffs over the Schedule A land, which the plaintiffs intend to prove by relying upon the Exhibit 1 registered sale deed, there is also a requirement to bring in the evidence of the vendors of the sale deed has to be examined. Firstly, the respondent defendants had not placed any proposition of law before the court that in the event the right title and interest claimed by a plaintiff is denied by the defendants, even the production, reliance and exhibition of a registered sale deed to claim the right title and interest would be unacceptable in law, and the contents of the sale deed would have to be proved by bringing in the oral evidence of the vendors of the sale deed. Igolo. Mr. Arkidi Chaudhary, just one, not your matter, to help him. Is there any proposition that when a registered sale deed is exhibited, the vendors will have to be examined? Registered sale deed. Registration is not denied by anybody.
so long as the because once it is
No.
registered, the vendor may not be there also. Once the
No, that's what we are asking. Is there any proposition of law? Because I'm holding it against. That's why I'm asking, getting it
So I
re-verified from you.
have not
Because I have not come across.
not come.
And secondly, it doesn't serve any purpose. Then why do you register?
Once the registration is proved, that's all.
Unless somebody denies the registration or say it is fake or something, is another aspect. But why do you have to bring in the vendor?
Lordship,
And suppose the vendor is dead, the land is
that
gone.
is gone. If he is dead, how can?
So don't buy land from a physically weak person, from an old person, because tomorrow he may die. And
After-
moment he dies, somebody will come and say, This is my land.
Of the records. I
And
always-
when you rely on a sale deed, you say, now bring back the vendor and examine.
No, this precisely, while dealing with civil cases, it is always in the back of mind. So whenever there is the question of witness, I always say you bring young witnesses.
Hmm.
Whenever there is a question of witness, I always say my client, you bring young witnesses who will stay for some time. So, because there's always a plea taken up in civil cases.
No,
So
but
far
this
as
proposition, we are not agreeing with it.
If registration is put,
Then why do you
I think it's
bring in
less.
registration? কি করলো? Other one, there is another question that Madam Devi's matter. So anyway, as you were here, this will take a little longer time. You may be busy. There is one section 86 of that Sasastra Simabol Act providing for summary proceeding.
yes,
Okay, there is another provision, section 85, providing for general force court proceeding. General force court is more elaborate. Summary is truncated, as the word summary itself will suggest.
Yeah.
86 is applicable only for people of constable and below in rank. This man who is dismissed for service, he is a constable or below. So they say, we have followed the procedure, we are following 86. But the allegation is serious. Some 6 rounds of firing through the official weapon, etc. It's when the allegation is serious, merely because 86 enables you to go for summary, why do you not go for the general force court? Because general force court is for everybody. It's nothing like that, that if you're constable, general force court is not applicable. This question we are unable to get the answer. Every time repeated submission is, we have followed the procedure. I know you have followed the procedure of summary.
I'll just.
Because whenever it is a serious, I think a more
Yes.
detailed procedure will serve the natural justice better than a summary proceeding.
Yes.
Constable and below, the word itself indicates that this level of people, at times, they are a little mischievous, little indisciplined here and there. Take care of these people for their smaller level of indiscipline and mischievousness here and there, or whatever it is. You bring in 84, say that you can sort it out in a summary manner. But when the same man is involved in a much more serious offense of firing 6 rounds with his rifle, do you think summary court will be sufficient? So what is summary? Man will be called to the office chamber of the commander.
Let's inform.
You have done this, that. Now dismissed from service. He doesn't even have a good opportunity to replying anything, nor any allegation, etc., are given to him in a proper manner. This is why we required you.
But I will just.
Please go to it. Devi,
Otherwise she is doing well, Lordship.
he is doing well. But this one, we wanted this specific answer. We are not getting it.
Lordship will take it up.
Otherwise, don't you think there is a possibility of abuse of power?
In the face of it.
Mhm.
Face of it.
Small things are okay. Huh? That you have eaten your meal twice today, you should have eaten only once. Okay. Small.
It is an incident of firing, Lordship.
Hmm.
More important.
It also involves a criminal offense also, firing of firearms. It's not just a case of indiscipline. And even if yes, it's a gross indiscipline, not just a trivial indiscipline. The question, why don't you go for a detailed inquiry? He may take any stand.
That will always be open for the authority.
Ah. He may take any kind of stand. He may.
Proper inquiry. As well.
Mhm. And the officer who comes, he is also very with a poker face every day. We have followed the procedure. Law gives us the procedure, we have followed it. Don't question us anymore.
Worship, they are made in that manner. Worship knows, otherwise indiscipline in a course, what if he holds otherwise? he
No,
will
no,
be in problem.
indiscipline we'll have to maintain. So therefore we have 86, but that doesn't mean,
The officer present here,
but,
he cannot say otherwise.
sorry,
The officer present here, he cannot say otherwise.
why not? We are putting him a very specific question of 86 and 84 both.
That is-
Mhm. He's a law officer, he's bound to answer.
That will put him in the
Another 86 against him also. Fortunately, he may be above a constable to escape the wrath of 86.
he is a commander, assistant commander.
Just look into this, because otherwise there is a possibility of abuse. This is number one. Number two, a commandant does not like somebody for some other reason. Just put him a kind of allegation. If you have done this, call him to the office. What you have to say? Oh, you're not satisfied. Go. If you put the constables at this kind of expose them to this kind of a situation where they have no protection under the law at all, they'll become more indisciplined. And they'll not respond to the call of the duty in the proper manner. They'll be very circumspect. If anything goes wrong, my job will go. Let me not do anything. Because I'll not have an opportunity to explain even if I do something in good faith, let me not do anything. And he is coming, please come in. It is double-edged,
Yes,
both ways. Unless the constables and below, they have a security in their mind that there is a law which will be protecting us. If you remove the umbrella of that security, they will be even more exposed and are likely to be less of utility. They'll take it only as a service opportunity, not as a service to the nation. Protect my service under any circumstance.
she will take it up after some time.
Whenever convenient.
Yes.
If not today, another date we can fix for you.
I'll try to do it. If there is any confusion of it, then I will make it.
Just see from this point of
Yes,
view,
yes.
from the point of view of the constable
Yes,
serving with a secured mind,
Definitely.
that there is somebody to take care of us. I'm not at all saying that this man should not be dismissed. That is something totally different
The procedure adopted.
on a procedure. लिखिए सिंधु, all of the top.
The opponent defendants did not place any proposition of law before the court.
They did not place any proposition law before the court that
Due to the event that affected
that
framed by a family, denied by independent, even the production is reliant on
exhibition of a registered sale deed will not be sufficient, and the vendor of the sale deed would have to be originally examined to prove the contents of the sale deed. The learned trial court in its the learned appellate court in its judgment dated 6/8/2011 also goes into the aspect that the requirement of section 67 of the Evidence Act would have to be satisfied in such a situation. Evidence Act on us. Yes. Mr. S.P. Roy, Land Counsel for the appellant plaintiffs, on the other hand, on the proposition as to whether upon exhibition, production and exhibition of a registered sale deed, the vendors of the sale deed are also, there is also a requirement under the law to orally examine the vendors of the sale deed, relies upon the judgment rendered by the Honorable Supreme Court in paragraph 13 of its judgment in Prem Singh and others versus Birbal and others, reported in (2006) within bracket AIR bracket SC 3608, corresponding to (2006) 5 SCC 5353, wherein it is provided as extracted. Para 13 colon ki. A reading of the proposition laid down by the Supreme Court in para 13 of its judgment rendered in Prem Singh Supra makes it explicit that whenever a registered document is validly executed, explicit that there is a presumption that a registered document is validly executed, and a registered document, therefore, prima facie would be valid in law. And the onus of proof against such registered document would be on a person who leads evidence to rebut the presumption. As there is a presumption in favor of a registered document of comma, as per the proposition laid down by the Honorable Supreme Court, comma, in the event respondent defendants intend to take a stand that the contents of the registered sale deed, Exhibit 1, do not prove the right title and interest of the plaintiffs over the Schedule A land, comma, it is for the respondent defendants to lead evidence to the contrary to show that the contents thereof would be unacceptable. In view of the above, the conclusions arrived at by the learned trial court as well as by the learned appellate court that the appellant plaintiffs, having failed to prove the contents of the registered Exhibit 1 registered sale deed to establish their right title and interest over the Schedule A land by bringing in the oral evidence of the vendors thereof. Line 2 quotes. In view of the above.
The conclusion read by the learned trial court as well as by the appellate court, with the appellant plaintiffs having failed to prove the content of the Exhibit 1
Comma.
registered
Comma. The appellant plaintiffs have failed to discharge their burden, comma, would therefore would be unacceptable in law. Furthermore, as already noticed, the respondent defendants have, even not in categorical terms in their written statement, had denied the right title and interest of the appellant plaintiffs over the Schedule A land comprising of 1 kotha, 1 lesa of KP Pata number 25, Dag number 20 of village Patasilambari Moses and so. And on the other hand, it is their stated claim that they are the owners and possessors of a plot of land measuring 10 lesas covered by, which is a government land and covered by Dag number 20 of Kalapahar so and so Gaon, which apparently is at a variance from the identity of the land over which the plaintiffs have claimed their right in title and interest. Furthermore, as already noticed above, in view of the variance of the description of the lands over which the appellant plaintiffs and the respondent defendants have claimed their respective right, title, and interest, and there being no material on record to identify as to which description of land, that is, the description of land claimed by the plaintiff or by the description of land claimed by the defendant, comma, is the identity of the disputed land, comma, we are of the view that unless a specific issue is framed on the same and the identity of the disputed land is explicitly stated, comma, no decision can be arrived at on the respective claims inasmuch as the plaintiffs and respondent both apparently claims right, title, and interest over plots of land which have a different description of, which have their respective different descriptions. In view of the above, the judgments dated so and so of the learned trial court in TS case number 2 and the appellate judgment dated so and so in title appeal number so and so are both set aside and the matter remanded back to the trial court to decide the respective claims of the plaintiffs and the defendants. Firstly, by framing a specific issue as to what is the identity of the disputed land involved in the present suit, and thereafter make an attempt to determine the right, title, and interest of the plaintiffs and the defendant over the identified disputed land by taking note of the respective evidences and materials that may have been produced. In doing so, the learned courts are also required to follow the proposition that of law that may be applicable in respect of the admissibility of a claim of right, title, and interest based upon exhibited registered sale deed. Accordingly, matters stand remanded back to the trial court for a fresh adjudication as indicated above. Both the parties to appear before the trial court on so and so. Send back the LCR. Any correction?
No, no, correct. I have filed a miscase lordship under order 40.
That is
One
become
to
infractuous,
20.
not required to be answered.
Then online maybe I will.
In view of the judgment rendered in RSS so and so, no order is required to be passed. Miscase.
So lordship, I may be in my petition for giving additional evidence. I may be that may be.
No, no, line based upon the materials evidence already on record. Full stop. If it is deemed desirable, the respective parties for may be allowed to adduce further evidence and material.
Then exhibit the.
No, definitely exhibiting. কি করলো? On the discretion of the library court may be allowed to adduce further evidences.
And add exhibit.
Evidence is exhibit. Exhibit is a part of the evidence.
That will be more clear.
You want the word exhibit. Okay.
Yes, Lord.
By, if necessary, by exhibiting any further material as may.
Oblige. MC is also disposed.
MC dispose because the
Yes, many
it's already covered by the others.
oblige.
Item
Tell
7,
your client, after hearing is over, we cannot allow lawyers to be allowed to be withdrawn.
Oblige.
কেমন দিছিল নেকি এইখন? কেমন দিছিল বোধহয়? Mr. Roy, I think you have given that document.
I am giving.
It's a court document.
Yes.
Oh, take a court of
Your
record.
Lordship asked me to take.
It's a part of the record. Yes, ma'am.
Right, please, your lordship. Lordship, I'm praying for an adjournment.
Item number
Item number 7, lordship.
7, yes.
Praying for an adjournment, lordship.
Adjourn on the prayer of নাম তো লিখি দিব।
Obviously.
item 8,
Lordship, past laws for time being, senior counsel, another court.
Timing, we don't know, 19 matter. Adjourn on the prayer of MS. Timing, we are adjourning it.
2013 matter, my lord.
13
His
matter.
Selection is a 2013, but he has not been able to get the job till now, my lord, because of this time.
Item number 8.
My lord.
No, it's a appeal of
19, my lord.
RS of
Next
19.
is okay, 2013, my lord. The selection matter, my lord, the service matter, my lord, in fact.
Service matter, why did he result it in a second appeal?
The file should
My lord, file suit, my lord.
ultimately first will second.
Why did you file a suit in a service matter? Hmm? Either he should have gone to the educational tribunal or to the Assam administrative tribunal or directly read petition before the High Court. You would have got the remedy much earlier. Suit is a very, very elaborate procedure. And is suit maintainable in a service matter? Hmm. Where is the jurisdiction of civil court, Mr. Mukhtar? Mhm. Tell Mr. Ahmed to read section 9. The court shall, subject to the provision contained, have jurisdiction to try all suits of a civil nature. What is a suit of a civil nature? This is number 1. Excepting suits of which their cognizance is either expressly or impliedly barred. It's a matter of appointment.
Election matter.
If it's a matter of selection and appointment, is it a civil dispute? Hmm. I think this, Mr. Mukhtar, come ready. We may have to decide this issue because a long time back, as a lawyer, I was required to handle one second appeal. It happened to be, is it a matter from Barak Valley, this one?
No, man, Dhubri, my lord.
Dhubri.
Lordship, substantial question, framing page number 5.
It may have been framed, but we are only fundamentally whether the civil court has jurisdiction to try a service matter.
Can it be taken up Thursday, my lord?
Think over it, because why I'm feeling, because somebody asked me to handle one second appeal, that too at the final hearing stage. It was, after reading, I found out that it's a matter of promotion. Some department somewhere.
Service matter, purely service matter.
It was origin of the dispute was almost 20-25 years back. Okay. Somebody files a suit, somebody gives a declaration, you have a right, so there is somebody goes for injunction, somebody goes for that, all kind of things happened. And ultimately, when the brief was handed over, I expressed this view that what to do. By the time the second appeal, you know, the PS certificate, it goes for hearing of a matter. The day I was about to argue, somebody informed the man has died.
There also only one has died, my lord, substitution has taken.
Why he has died? Because it took almost 25-30 years to decide one promotion matter. Had he not come to in a civil suit and he come to the writ or tribunal straight away, it would have been decided at least 20 years earlier. The man during his service tenure would have got the benefit of a promotion. What was handed over in second appeal was of a retired man. Had he got the benefit, he would have got some
Yes, financial benefit.
marginally 200-300 more of pension here and there. That's all. What about the deprivation of his promotion for the entire career? Why do you go for suits for everything? When the law has provided you 3 good alternative ways, much faster relief. If it's a venture school, it will be tribunal.
Right.
If it is a government school, Assam Administrative Tribunal. If you don't want to go there, we are entertaining writ petitions day in, day out. You'll at least get a decision within 2 to 3 years, whatever it is.
Seven.
Thursday. Oh, let's wait for this one. If you do not want to press the suit, I'll give you liberty to go for a proper adjudication, but don't trouble this man now. You are appointed, selected,
I have been selected as serial
Vice
number 1.
President.
Aha.
He selected
Vice
3, my lord.
3. And what is the ground?
Ground is that, my lord, that I was ace barred at the time of application, my lord. But before my lord, that interview, my lord, in the written statement, my case has been broken down, my lord, for 5
Okay.
years. That is the only case.
And you are yet to be appointed.
Yes.
Thursday.
Thursday. Right.
That's why I say you should not go for
Yes,
suits
yes,
in all
Thursday.
these things.
Yeah, please, Your Lordship. Your Lordship, this is an appeal under section 23, Your Lordship, of the Railways Claims Tribunal Act, Your Lordship. And it's a miscellaneous first appeal, Your Lordship. Your Lordship, may I start with the very facts of the case, Your Lordship? Yes. Your Lordship may very well peruse the very evidence of affidavit filed by the claimant, Your Lordship, wherein, Your Lordship, the very incident which had happened, Your Lordship, on 21/1/2018, and it was given by the station superintendent of the station, SNCR railway station. Your Lordship may very well peruse exhibit memo number 1.
Why your claim was rejected?
Your Lordship, my claim was rejected on the very ground that the seizure list which was being prepared by the inspector in charge of the railway police, Your Lordship, they had prepared the seizure list on 21/2. When Your Lordship perused the seizure list, the date which was given down below was 21/2/2018.
And
Your
the
Lordship.
accident happened on?
21/1/2018, Your Lordship.
That's a reason.
Yes, that is the reason, Your Lordship, primarily, Your Lordship.
Whose fault it is? It is the fault of the dead man, or it is your fault?
That is not the only case, my lord, at the
No,
time.
we'll come to this, on this aspect. If you put the deed into Caesar list to be 1 month later, can it be, where is the reasoning? Let us see why it was rejected in the judgment.
Yes, Your Lordship. I'll just take Your Lordship. Your Lordship, Your Lordship may very well peruse the judgments from Your Lordship, pair number 11, Your Lordship,
Para 11.
page number 18, Your Lordship.
Hmm.
May I read, Your Lordship? Your Lordship, after considering the above judgment, it is seen that AW1, who appeared on the witness box, has not filed the original journey ticket, which she says was handed over to her by the official police officials. Only a photocopy has been furnished, which is not legible and disputed by the railways for reasons mentioned above.
And where is the original journey ticket?
Your Lordship, actually, Your Lordship, when the investigating officer was called for the examination by the learned tribunal, at that particular point of time, the investigating officer of the railway police was investigating had retired. So on his behalf, there was another officer who had appeared before the court and had submitted the original case diary. In that original case diary,
Oh,
Your
no, Mr. Tendeka, where is the original ticket?
Your Lordship, as per the court, Your Lordship, in the original case.
No,
diary-
where is the Caesar list? Let us take a
Yes,
look
Your
at the
Lordship.
Caesar list.
Caesar list, Your Lordship, would
Page
find
number,
exhibit 3, Your Lordship.
page number,
Page 11 of the LC, uncle.
Page 11 of the.
here.
Yes.
Yes, Your Lordship.
Page 11 of the LC. From the top.
Hmm. Page 11 is statement of witness number, Rameshwar.
From the top. Yeah.
Top means,
Handwritten, and there is also a typed copy of the.
Yes, Your Lordship.
no, we are not asking that. Who is in possession of the original ticket?
According to the pleadings, my lord, this.
No,
ticket
not
was
according to pleadings. Who would be in possession of the original journey ticket?
applicant.
Applicant. Did after the death of the person, did the police seize the railway ticket?
Yes, Your Lordship, it is submitted from the
If
final.
it is seized, it is the seizing authority who is in possession. And it is under the law, it is for them to produce it.
At the time when the inquest was conducted on the dead body, my lord, no ticket was found. Subsequently, this Caesar list comes out from nowhere after a month saying that a ticket has been recovered from the pant of the deceased person, and that
So
was recovered by the elder brother of the deceased, my lord, not by the police.
whatever it is, it's a Caesar list.
Oh,
And in that second, after a month Caesar list, it contains the journey ticket.
yeah,
So,
according to the police.
you are the custodian of the record. Just a minute. When and who had issued that ticket? It is for you to inquire.
It's an
See,
unreasonable.
if you have a document in your possession, which is from this court, I have the record to examine from where the document occurred. Was it a genuine ticket issued by the railways prior to the journey of this deceased?
My lord,
Why will you not make that inquiry?
that inquiry can be made, but
See, I think Evidence Act is against you. 106 of the Evidence Act is likely to be applicable against you. Please look into it. It may have been seized after 1 month, no difficulties. So there is a possibility of the ticket being a fake ticket. That on the day of the death, it was not in the pocket. After 1 month, from where did it come from? But it is a ticket. If it is a ticket, if you look at 106, burden of proving facts, especially within the knowledge. So this ticket is a genuinely issued ticket by the railway, or it was never issued by the railways, or it was issued to somebody different, or it was issued at a time prior to it, or later, or fabricated. It is you who will have to discharge that burden. Once you discharge the burden, that our record reveals that this ticket was never issued. End of the matter, if you go against them.
my lord, we can very well ascertain whether the ticket.
You
was issued
ascertain
or-
and tell us.
But the thing is, my lord, it is an unreserved ticket, my lord, so the name would not be there. So it's difficult to ascertain to whom it was issued. So
Doesn't matter,
it's our case,
doesn't matter. How many tickets were issued that day? Same ticket. From that station to Morkong Select, how many tickets were issued? That record you must be having. If you have absolutely no record, then the presumption will be against you, that you can never rebut it. Who can rebut?
that record we
Mr. Sharma, what is the law of rebuttal? There is a huge confusion everywhere. Law of rebuttal is not that, I don't do anything, I deny, you prove it yourself. That is not the law of rebuttal in every case. Law of rebuttal is, rightly or wrongly, he produces a ticket, he exhibits it. You being the custodian record will have to tell us to rebut it, that no, this is not the ticket issued to this man. Even an iota of evidence will accept it. But if you don't do anything, you just throw the burden on the other side.
now.
You don't follow the Evidence Act.
Here is a case, my lord, the ticket has to be proved in original. That was never exhibited.
But
It is not there.
Mr. Sharma, don't go in this concentric circles round and do the same thing again and again. It's a sheer wastage of time of everybody. The ticket was seized. It was seized by your authorities.
No, not our.
Then who had seized?
Police, Assam police.
Assam police.
Yes. Not
The Assam police must have rendered evidence of that seizure.
No, that person was called, but he did not depose.
So you are denying the seizure list now. You cannot. Seizure list is not a mere denial. Tomorrow, if every seizure list, only a denial is there, see the advantage you are giving to an accused anywhere.
That person,
A man will commit a murder and the seizure list will only denial. No. This is not a seizure list. End of it. Don't acquit me. Don't convict me.
now that document and the aspect of seizure has to be proved, my lord. That person has to be examined. So railway cannot produce that person, my lord. Either the tribunal.
So who had conducted inquiry in this case? Railways or the
There were
Assam
two
police?
inquiries, my lord. One by the railway, under the Railways Act. Other one was by the Assam police. Assam police.
What is the law when two authorities having concurrent jurisdiction makes an investigation? What is the law?
If I may clarify. okay, my
Is
lord.
the law that I'll rely only on my inquiry, not on the other one?
No, my lord. The purpose of the investigation conducted by the Assam police is
Mr.
are different, my lord. Purposes are
Maybe
different.
in order to take a complete defense, it was for you to call for the records of the Assam police investigation, number one. Number two, seizure will contain witnesses. If the official who seizes dies, that doesn't mean the seizure also disappears. Witnesses are there.
Yes, it was the elder brother of the appellant.
So he had deposed.
No, he had not
No,
deposed,
Your
not
Lordship, he did
deposed.
not depose.
He was also not examined, my lord.
Then who was examined in favor of the accuser?
Your
Not
Lordship,
the
only
one.
the appellant was examined, Your Lordship. And Your Lordship.
Appellant is this lady, this
Yes,
wife.
Your Lordship, and she had deposed before the court, Your Lordship. And Your Lordship, the actual investigation was done by one PC Milik, Your Lordship. When Your Lordship sees peruses, Your Lordship, the final report was also prepared by him. But in his, Your Lordship, final report, down below, if Your Lordship peruses that he is the officer in charge of North Lakhimpur Government Railway Reserve Railway Police Station, Your Lordship. So he is an inspector in charge of the railway police, Your Lordship. And police under the 7th schedule also would include the railway police, Your Lordship. So that is, it is,
GRPS is Assam police, my
Uh.
lord. GRPS, Government Railway Police, my lord, it's Assam police. They are deputed.
Where is the railway claims tribunal? Let us see. Making it unnecessarily complicated. According to the Railways Act, according to the Railway Act, in case of a death of a passenger in railway, who will investigate
Your Lordship.
Dear,
this
there
section?
is a rule, my lord. I can hand over the rules, my lord.
It's called, Your Lordship, Railway
There is-
Passengers
It's
Manual.
not both of you at the same time. Let him complete.
The railway accidents and untoward incident compensation rules 1990. This is the rule, my lord. Under the provisions of this rule, my lord,
The railway,
the railway passengers manner of investigation of untoward incidents rules in 2000.
it is there, 2020 rules.
2003, my lord.
No, it's 2020.
Probably subsequently it has been amended.
So this case was under the 2003 rules.
Probably.
Let us see.
Even if it is amended, it would be
Hmm.
minor one. Even if there is an amendment, those would be minor ones.
This is under 129 of the Railways Act. And which rule you are relying?
6, 7, my lord,
Six.
from 6 onwards. Those are the rules pertaining to conducting the inquiry.
So 711 on receipt of information under Rule 6, that is some untoward incident had taken place. An officer of the force means Railway Protection Force, not below the rank of inspector, shall carry out the investigation and shall, obtain copies of inquest report, postmortem report, Jama Talashi report from the police investigating the agent. That means the local police.
Okay.
So it is for you to get the entire information for them.
That was done. Is there in the record?
Uh,
Inquest report, everything was,
no, did it contain the Caesar list?
some-
Rightly or wrongly, Assam police has a Caesar list.
Exactly.
Whether Caesar list is admissible or not is another factor. But under 711, you'll have to bring it and be fair enough to produce it. And after producing, you may take a stand that this is a fabricated Caesar list, but you cannot leave it to the claimant.
Probably that finding is there in the report, my
Which report?
DRM report. Report.
DRM report is of no value to us.
DRM report is prepared on the basis of the investigation carried out by the RPR.
By the RPF, I understand. So whether the RPF had done the requirement under the law, find out. The report will be of no value
But-
unless the RPF had taken the necessary steps under 711.
They have taken, but they have not taken over the original documents from the.
You have to do it. Number one, obtain copies. After obtaining copies, you'll produce these copies before the court during the claim. And whenever required, you will make an application. Please call for the original. The tribunal has the jurisdiction to call for the original from the Assam police.
That was called for. That case
So-
study was there.
Did that case study contain the Caesar list?
Caesar list was there, probably there, but
Moment it contains, it's a part of the record. It is admissible unless
the ticket was not.
if the Caesar list contains Caesar of a ticket, ticket has to be there.
Not there. Judgment revealed.
Judgment is not everything for us. Therefore, we are in appeal. Judgment is not a evidence before the court.
The honorable tribunal.
So we send it back. You call for the ticket. Once the ticket is produced, it is for the railways to rebut it under 106 of the Evidence Act that this was a ticket never issued by us, or it was issued to somebody, or it was issued subsequent to the death of the occurrence. So it is not of this disease. Whatever stand you take. Otherwise, how will you get the justice?
But according to the,
Mr. Sharma, check a little logically.
I understand my what.
A citizen is before the forum claiming some justice. That has to be looked into from the proper perspective.
I understand.
This is not there, that is not there, so end of the matter for the tribunal. It is not the approach.
What I'm trying to say is, Malak, if you should permit, we can very well ascertain whether the ticket was issued or not,
You do
but
it.
we cannot get the original ticket. Malak, because it is-
Original is seized,
it's in the.
not
custody.
his. Original, you are linked up with the investigation of the police by virtue of 711. This is the link. It's not that you are RPF, one entity, claimant, and the Assam police is another entity, and both of them are together. It is not the case. In fact, Assam police is also part and parcel of your investigation, and the link is by 711.
But
That's
according-
the first question I asked. When two authorities have concurrent jurisdiction to investigate a matter, what is the law? This is the law.
According to her deposition, it was in her home. Okay. That is why.
One widowed lady is before the her husband has died, want some compensation. Lawyers will be there, this will be there, one tribunal member, intimidating character will be there in standing in front. Maybe a little slip here and there, anything may come out of that. But fact is, there is a Caesar list, ticket was seized, it was seized by the Assam police. Assam police is linked by 711 with the railway police. Call for the cops. And when that is the investigation stage, when the stage of the tribunal comes, call for the record from the Assam police. If they don't produce, we'll direct them to produce it before you. And if the records contain, then the question of 106 in respect of the railways. Otherwise, there is a presumption in their favor. Yes, this is a genuine ticket he was traveling. The rebuttal has to come from the railways. If you put the onus on him, how do you expect that dead man to come forward and give evidence? No, I purchased this ticket from this counter on so and so there.
That is not the law, but
So the rebuttal from the other side, not from his side. Nor the wife can give evidence.
according to the latest decision of the apex court on the subject matter, my lord,
Let us see.
that has been quoted in the judgment itself.
Forget about court. Let us see. Read the whole judgment.
That portion of the judgment, my lord. I can hand over one.
Give the citation, we'll take out if you don't have.
I have the initial burden would be on the claimant side. That can be.
What is initial?
Going into it.
You will not go, you will have to go. What is initial burden? Moment the ticket is claimed that this is the ticket, it is under seizure, initial burden discharged. This is what we are facing in the foreigners tribunal also. Initial burden doesn't mean a man will be holding a stick, that you go on discharging the burden till I am satisfied. Only when I will declare that I am satisfied, the burden is over. It's nothing like that. Initial burden is a material which will prima facie discharge the burden, not conclusively. Moment that is given, rebuttal is on the other side. No.
Yes, sure, okay. The contention of the railway is that this has been, Lakshmi condone me for saying this, this season, this ticket has been
Mr.
granted.
Sharma, we are aware that there are a lot of false claims. For there being 10 false claims doesn't mean the 11th is also false. And no court can dismiss a claim because there are already 10 false claims. The 11th one, this is also false, dismiss it.
So that the tribunal to apply its mind to given facts and circumstances of
No,
each case.
no burden is on the railways, not even on the tribunal. You discharge a burden, we'll definitely take note of. Discharge an iota of the burden. Definitely then the duty of the tribunal to get into it, give a finding. Very well. So para 19 prima facie it goes in their favor. As per the ticket verification report, ticket was issued on air date 10:15 hours. And the so-and-so UP train departed from DMC station at 11:20 hours.
Yes, sir.
Quite reasonable to this extent. On suspicion. Rejection on suspicion.
Not only on suspicion, my lord, because the inquest,
Mr. Sharma, the word used is highly suspect.
because
I'm reading the judgment and saying. How many tickets were issued? And this must be a small station, I think. No? What is the name of the station?
Hemaji.
Huh?
Hemaji railway station, Your Lordship.
Hemaji railway station, train going to Morkong Select
Yes, Your Lordship.
during 2018. Broad gauge was already started around that time, 2018.
Probably, my lord, I'm not sure. Probably. it has
Just
started.
about started.
Probably.
How many tickets were issued?
Yeah.
Suppose only one ticket was issued, then
Because it was a starting station, it would be more than one, my lord. Hemaji was a starting station. for
Dhemaji was a starting station
For
of
that
this
train,
train.
probably. For that train, probably.
Your Lordship, I don't have it.
Probably for the train, my lord.
Just because Dhemaji is a quite a faraway place, and Morkong Selek is very near to that one. Will the railways have one train from for such a short distance? This distance, I think it won't be more than 20-30 kilometers, Morkong Selek and Dhemaji.
From Hemaji to the place of accident, it would take around half an hour by train.
Understand. Distance between Dhemaji and Morkong Selek not likely to be more than 20-30 kilometers.
No, it's
So,
more than that, my lord. I
how-
can get.
What is the distance? Find out.
It takes 2 hours to reach Mokok Cheleng from Hemaji. 2 hours.
Understand or distance.
Distance are not aware, my lord, but it
Just
takes
see.
distance in kilo 273, 375. 357 minus 270.
357 minus
273.
57 when about 80 kilometers, 70-80 kilometers.
So, 357. 84. You're 84.
84, something like that only.
102, 357 minus 2.
Not 100, it is 80. Either 70 or 80.
357 minus 273. 273. 73. 84.
84.
It takes 2 hours to reach Mokok.
Mr. Sharma, with our experience of railways, unless it is a very, very high load capacity route, railways never introduces one train for about 80 kilometers.
No, I'm not sure, my lord.
It's a very rare.
But-
Even in those local trains of Calcutta also, it travels more than 80 kilometers,
Really?
where every train will be full to the maximum extent.
That submission was.
There
made to
is
the
a
secretary.
passenger train between Guwahati and Bongaigaon. Reason is there. There's a huge passenger load. Lot of people come to Guwahati to attend office daily,
Daily.
reaches at 9, evening 5, 5:30, it goes back. It's a huge load. Dhemaji and Morkong Selek, that you will operate one whole train only for this.
Well, that's my presumption only, my lord. I'm not sure about that. But the deceased person, he boarded the train from Hemaji, my lord, and en route at a place called Pani, my lord, Sri Pani railway station. He met with the accident.
But as you are dismissing only on the ticket issue, means it is not an untoward incident.
That aspect has not been gone into by the train. Whether the person.
Then why did you dismiss?
Not me.
It is, after all, your tribunal only to decide your issue.
They're independent authorities, my lord. We don't have extra.
Maybe. Mr. Sharma, we are aware.
No, not at all, my lord. We do not exercise.
So why was it dismissed then? What is your case before the tribunal?
Our case is that, my lord, our case is twofold, my lord. We dispute that this particular ticket was seized by the police. We dispute the genuineness of the ticket because at the time of inquest, my lord, nothing was found on the body.
That's a suspect.
That-
Therefore, the word highly
That's
suspect. Yes,
suspicion.
then-
And the second ground from the written statement, my lord. What I what I could gather is that the person died because of his own negligent act, my lord. He was sitting on the footboard of the,
Have you
Coach-
proved it
my lord,
or presumption?
from the DRM report.
Report based,
Report
based on?
Based on the claims of the witnesses. The witnesses were examined, my lord. And on that basis,
But only report, you have to bring the witness.
uh, according to the,
Understand, a report,
my lord.
a report is not the primary evidence. Primary evidence should be the co-passenger.
the person
Co-pas-
who has
A
seen-
co-passenger can give an evidence. Yes, I saw this man. He was sitting in the footboard, dangling out. He was not in a very good condition, fell down. It's his own self-negligence, but not based on reports.
What I would submit, my lord, according to rules, my lord, this report is required to be submitted along with the written statement. And this is,
Report is not conclusive, Mr. Then let us not go to that issue. Another issue will be decided against you. You'll have more trouble. Keep it open for a subsequent day.
whatever,
Reports are never conclusive.
whatever I could gather from the pleadings, my lord.
Understand? Reports are never conclusive. Reports are only indicative.
Probably these are the two grounds of the review.
So you have to, negligence, you have to prove it yours.
Yes, Lordship had asked me, my lord, I have submitted. After going through the report, written statement, I could find only these two grounds.
Heard Mr. D.S. Decker.
Yes.
Learned counsel for the petitioner, also heard Mr. B. Sharma, learned counsel for the respondents in the railways. This ticket issue is sending back, call for the thing. May take a more conclusive value rather than a suspicious call.
Well,
The petitioner, the appellant Madhumita Phukon instituted a proceeding under section 16 of the Railways Claims Tribunal Act 1987, read with section 124 capital A of the Indian Railways Act, claiming compensation amounting to rupees 10 lakhs, along with interest and costs for the death caused to her husband Domboru Phukon, alias Domboru, or Domboro Phukon, alias Domboru Phukon, who was traveling in the train number 551813 up from Dhemaji railway station
Yes, your lordship.
to Morkong Select.
Yes, your lordship.
When she fell down from the running train at a place called
Your lordship, Sri Pani railway station.
Sri railway station. Train was moving or was
Your
stopping?
lordship, he fell down when the train was at the last yard end of the train, your lordship. He fell down when the train was.
They're from a moving train at Omuk se Kiwaki to Pani station. Died on the spot or,
Yes,
or
your
in
lordship,
hospital.
he suffered grievous injuries. His both legs were cut down, your lordship.
He was
Ah.
taken to the hospital en route he died.
And he died.
The deceased husband of the appellant suffered grievous injuries from the fall from the running train, resulting in injuries to both his legs, but he could not survive and died on the way to the hospital. Without going into the details of the claims and counterclaims, claims and denial of the appellant and the respondent railways, what we take note is that in case of the proceeding, the appellant, while in her deposition, stated that in course of the proceeding, a photocopy of a railway ticket was brought in evidence. And the appellant in her deposition stated that the photocopy was handed over to her by the police officials Full stop. The tribunal in its judgment, in the impugned judgment dated 27/1/2020, in paragraph 11, arrived at its conclusion that AW1, who appeared on witness box, had not filed the original journey ticket, which she says was handed over to her by the police officials, and only a photocopy had been brought on record, which also is not legible. But in paragraph 12 of the judgment, the learned tribunal took note of a report dated DRM report dated of the divisional railway manager, date to blank thoi diya ha, side report. Mr. Sharma, can you help us with the date of the DRM report?
Yes, it's on record now.
Report dated so and so of the division manager,
9 September 2019.
9/1/2019, wherein, as extracted by the learned tribunal, in paragraph 5 and 6, it was provided as extracted. Page 19 or huh? All DRM report to quote koribo. Gote parato na lage. Paragraph 5 of the report of the DRM provides that the UTS ticket number 651-64369 was found from the possession of the deceased person, which was seized on 21/2/2018, whereas the incident took place on 21/1/2018. And in the spot inquest that was conducted by the GRPS stroke NLP. What is GRPS? Government Railway Police.
It's Assam Police.
Okay. No journey ticket was found from the possession of the deceased. CRPC consent. Para 6 of the report of the DRM provides that the ticket verification report of UTS ticket numbers 651-64369 revealed that it was issued on 21/1/2019 at 10:15 hours at Dhemaji railway station.
Yes, sir.
And as per the record, the train 55813 UP departed from DMC station means
Dhemaji.
the place where you board, is it called DMC station or it is the name of Dhemaji station? From DMC station at 11:20 hours on 21/8/2016. From the information provided in the report of the DRM, that the ticket was purchased at 10:15 hours on 21/1/2019 and the train departed at 11:20 hours on 21/1/2018, we can prima facie accept that the issuance of ticket was at a close proximity of the time and date of the journey. But however, by relying on the provisions of para 5 of the report of the DRM, the learned tribunal arrived at its conclusion that as the seized ticket was in a seizure list, which is dated 1 month after the death of the incident, therefore it is therefore there is a probability of it being highly suspicious. And further, although summons and CD, so when he did not come to court, he means, and further, the inquiry officer which resulted in the seizure list had not come forward to the court to in spite of summons and not come to the court along with the case study in spite of the summons.
Subsequently, he came and handed over the case.
And this is the reason they have given, we go by that.
Dhamaji, DMT is Dhamaji.
From DMC bracket Dhamaji Gurdiya station. From the above, it is discernible that firstly, whatever the photocopy of the ticket produced by the appellant was rejected for it being a photocopy. In spite of there being an explanation that a photocopy of the ticket was provided to her by the police officials who had conducted the seizure. Secondly, the tribunal took note of the fact that the seizure list is dated 21 to 2018, whereas the death occurred on 21/1/2018, and that during the inquest conducted by the GRPS/NLP, no ticket was found in the possession of the deceased body. Can a deceased body possess?
It was ultimately found in the pocket.
No ticket was found on the deceased. And therefore, it is highly suspicious that the journey ticket relied upon is actually the journey ticket that was issued to the deceased. Black's-Law dictionary ko nasa yun. Where is the provision for holding an inquest?
That is under the CRPC.
Which section? Mr. Where is the provision to hold an inquest in case of a death? Even we have to check up. Hey, CRPC kon diyo.
174 probably, my lord.
174.
To inquire and report. Report on the time to 174. This is inquest report.
To hold.
174.
74.
74. And
We are asking this question, Mr. Sharma. My concept of an inquest is it's normally done by an executive magistrate on the question how the death had occurred. It's not a complete search of the dead body. normally the legal purpose of an inquest is the first-hand opinion to be formed how the death had occurred. And not a complete search of everything that it has and it does not has. So the authority conducting the inquest has no necessity to dig around the pockets of a dead man,
Yes, Your Honor.
whether it contains a ticket or not. So reliance on the thing that inquest did not reveal the ticket may not be the appropriate legal basis.
Yes, Your Honor.
Of course,
At
Yes.
this moment, I cannot say, but I have not gone through all the provisions, my lord.
no, I don't know. If your concept is different, we don't know. You are welcome to educate everyone. But
That's it.
basically, the purpose of inquest is to cause of death.
What seems, my lord,
Hmm.
the plain reading?
Cause of death, what was the color of the face, whether it was pale, that means whether the person died long time back, whether the body was stiff, whether blood was coming out from somewhere. These are the factors. Mhm. So the authority conducting the inquest will never check the pockets of a man. কি লিখিলো?
And they're doing the inquest conducted by the DRPA no ticket was found from that. And that's the reason-
No journal found found in the possession of the deceased,
and therefore it is satisfied.
and therefore arrived at its conclusion that it is a highly suspect that the journey ticket relied upon by the appellant would be acceptable in law. The other reason for not accepting the journey ticket relied upon by the photocopy of the journey ticket relied upon by the appellant is that in spite of summons having been issued to the inquiry officer of the GRPS/NLP who had investigated the death of the husband of the appellant, the inquiry officer did not respond to the summons. And the case study produced did not contain any original ticket. On the aspect that, in spite of summons having been issued, the inquiry officer of the GRPS/NLP did not appear, we take note of the provisions of section rule 7(1) of the railway passengers manner of investigation of untoward incidents rules 2003, which provides that in the event a station superintendent receives an information of an occurrence of an untoward incident, an officer of the force, which is to be read to be the railway protection force, not below the rank of an inspector, shall carry out the investigation and shall obtain copies of the inquest report, post-mortem report, and Jama Talashi report from the police investigating the incident. The provisions of Rule 7(1) of the Rule 2 short rules of 2003, which is stated to be applicable in the present case, although subsequently we have the railway accidents and untoward incidents bracket. No, railway.
Railway passengers manners of investigation.
No, that's the only one. There's no later one, I think.
2003, ma'am. According to
20,
this-
I think that's the only rule. You look. Please. Upon is here, then. No, not like it. The provisions of rule 711 of the rules of 2003 makes it explicit that it is incumbent upon the appropriate officer of the Railway Protection Force who shall carry out the investigation of the untoward incident to obtain copies of the inquest report, postmortem report, and Jama Talashi report from the police investigating the agency, meaning thereby, in the instant case, the GRPS stroke NLP. NLP, in whose case diary the Caesar list dated 21/2/2018 is available. When the provision is that the investigating officer of the Railway Protection Force shall obtain the copies of the inquest report, postmortem report, and Jama Talashi report, it has to be understood that such materials are also to be a part of the investigation by the Railway Protection Force. And it is not that only when a claim is lodged before the Railway Claims Tribunal, the court would be required to issue a summons to the inquiry officer of the police to produce the case diary and remain present for his evidence. In the absence of the aforesaid procedure being followed, it has to be understood that the investigation done by the investigating officer of the Railway Protection Force was done in a truncated manner without following the complete procedure. And it is for this reason that the investigating officer of the Railway Protection Force could not investigate the aspect as to whether the deceased person was traveling with a valid ticket or the ticket seized as per the seizure list by the police would be a ticket which was not issued to the deceased person. Further investigation by the Railway Protection Force as to whether the ticket that may be available in the seizure list was a genuinely issued ticket or whether it was issued to the deceased or to somebody else would be a matter of investigation depending upon how many tickets were issued to for traveling from Dhemaji to Morkong Select in respect of the train number 55813 UP on that given day. As the ticket in original, which was seized by the seizure list dated 21/2/2018 and was in the records of the GRPS/NLP who had investigated the death of the husband of the petitioner, the claim of the appellant for having produced a photocopy of the ticket which was given to him cannot be a reason to dismiss the claim without making any further inquiry. This DRM report, let us not put it. It will complicate matters for you in other proceedings. That a DRM report is not evidence. It is only an indication. Report has to be proved. It's in the nature of a preliminary inquiry in a departmental proceeding. That report has to be again proved. Just a preliminary inquiry report cannot be an evidence in a inquiry. I think you know the law. Piccolo. We further take note of the report of the DRM dated so and so on his conclusions in paragraph 5 thereof that a ticket being issued to the claimant, deceased husband of claimant, has to be disbelieved because the same was not found when the inquest was conducted on the dead body after the occurrence. In this respect, we take note of the provisions of section 174(1) of the CRPC, which provides for the requirement of an inquest to be held either by an executive or by an authorized official. Inquest on a dead body, as per the Black's Law Dictionary, means an inquiry by a coroner or medical examiner, sometimes with the aid of a jury, into the manner of death of a person who has died under suspicious circumstances or who has died in prison. To quote which is quoted as below. A meaning of the word inquest makes it discernible that it is merely an examination on a dead body on the reasons of a death, and it does not include a thorough search of the contents which may be found inside the clothes worn by the person, the clothes found on the person of the dead body. From the purpose of the concept, from the point of view of the concept of an inquiry, as because the ticket could not be located at the time of inquest, cannot be a reason to disbelieve a ticket if it was otherwise subsequently seized in course of an investigation. the availability of a ticket which is claimed to be a valid journey ticket may be rejected for other reasons. Based upon materials that may be led by the respective parties in course of a proceeding. But merely because of a reason of it not having been found at the time of inquest may not be a sufficient reason to discard a ticket which otherwise is available on record. In view of the matter, the rejection of the claim of the appellant by the judgment dated so-and-so is set aside, matter remanded back for appropriate conclusion as to whether that ticket as available in the seizure list dated was actually from the possession of the dead body, from the possession of the deceased husband of the appellant, and if yes, whether the said ticket was a genuine and valid ticket that was issued to the deceased prior to his journey. With definite conclusion. For the purpose, either of the parties may lead any further evidence as may be advised. And the investigating officer of the government of the Railway Protection Police Force may also do the needful as provided under rules 711 of the rules of 2003 for ensuring that the appropriate records are available before the tribunal for an appropriate adjudication.
DRP may also be directed to cooperate, my lord, because it is their evidence that would be.
No. If summons are issued, no one is coming, there is a procedure. The tribunal to follow. On the submission of Mr. B. Sharma, Land Counsel for the Respondent Union of India in the Railways regarding cooperation of the officials of the police who had done the investigation on the death of the husband of the petitioner. We provide that we have taken note of the observation of the tribunal that in spite of summons, the inquiry officer is not appearing. Inquiry officer or any other appropriate person is not appearing. And observe that in the event a court of law has issued summons and someone is not responding to it, there is an appropriate provision of law which may be invoked by the tribunal to ensure the presence of any such person. And such procedure may be adopted by the tribunal. Tribunals are not that we cannot do anything. They have enough power. You can issue non-bailable warrant and bring that man.
Your lordship, may I just submit, your lordship? Your lordship, there is this issue which that the investigating officer did not appear before the tribunal on the summons issued because he had retired at that particular point of time, your lordship. And then your
Then
lordship,
it is for the officer in charge to come and say something. And whosoever is the custodian of the record at that relevant point, he should come.
he also.
We are not here to give legal advice, Mr. The law is clear. Why do you need the inquiry officer? Because he is the custodian of the record.
Yes, sir.
In his place, whosoever is, that man will come. We are here for the petitioner. What is to be done today? Today, what is to be done?
matter may fix for admission hearing. And the earlier order may.
Admission hearing. Admission,
Lordship, otherwise, Lord, if your lordship is to take the matter today.
you are ready? Who else appeared? You are for the petitioner.
Lord.
And you are for the
Number one.
respondent and others.
Lordship,
You- Lokhipur, Gwalpara, no, Kachar.
Lordship, Lordship.
Your officers are divided. Block Development Officer is by Mr. Mojumdar, State of Assam Deputy Commissioner, you. Sorry. No, that's what they are doing. Is the government divided? One officer wants it this way, others want it the other way.
Lordship, Lordship, 1 and 2 are the dependent in the suit, Lordship. That's why I have made a that formal party, Lordship.
And,
Yeah,
and the petitioner is also a defendant.
Lord, I'm the defendant number 2 in the suit, Lordship.
Understand? Normally, a regular suit is okay, but when the suit is against the government, can one of the government officer come out and take a different stand, and the other government officers will take another stand? BDO is a government officer, I believe.
Lordship.
He is not an individual person.
No.
Deputy Commissioner also government.
But I think
So
they-
all of
they
them are
not-
defendants. Now what do we hear? Deputy Commissioner taking a different stand, BDO taking a different stand.
My contention is that they may not object. Lordship, they are, it is the case of the Lordship.
No. Had all the government officials been petitioner before us, we understand. Then there would not have been any difficulty. The junior engineer, he is also a government officer, deputy commissioner, government officer, BDO government officer. All three, as petitioner number 1, 2, 3 files this revision. It's okay.
Only 2 fighters.
But now, suppose I allow you, deputy commissioner is with the petitioner or he'll oppose this petition? He'll oppose it. You are in favor of the petitioner. The line we understand. What is your stand here? You are opposing the revision petition or you are favoring the revision petition? Opposing. So according to you, this revision should be dismissed. And according to another government officer, BDO, it should be allowed. Is it not a conflict within yourself? This is the reason why I'm asking you. Where is the Wakalatnama? Who had given the petitioner the Wakalatnama? And what is the suit for?
Suit basically is for declaration of right title interest, confirmation of possession
Over?
over the suit land bought by the plaintiff from the vendor. Now, here is a case of the BDO.
No. Who is the vendor?
Vendor.
The deputy commissioner vendor?
No. The private party. Obviously, I have purchased the land from a
Then
private.
in the revision, where is the private party?
In the revision, there is that
No, where is the
That's
plaint?
number 1.
Where is the plaint?
plain in his petition, my lord, if the pagination is correct, there is no pagination in my copy. It is after page.
Yes, Mr. Mojumdar, where is the plaint?
Lordship, it is kindly have a look at page 54, annexure 5.
Page number
54, annexure 5.
4. This is the plaint.
Lordship.
This is the.
Who appears for Noven Kumar Singh?
I am the.
You are. What are you claiming here?
My lord, here my right title interest was clouded because of my lord, an activity of bond taking carried out by the block development officer.
Sorry?
there was a pond digging. There was digging of a pond within my scheduled land premise.
So government is digging a pond in your
Pond.
land.
Specifically, it was the BDO who was carrying out, under whose instructions that activity was being carried out. Now, to that, there being a clouding of my right title interest, I filed this suit, making the state a party, the block development officer a party, and the junior engineer a party. But my basic grievance is against the block development officer.
So Lordship, the issue was earlier,
This revision, my lord, is before your lordship against an order of rejection of a section 11 CPC petition by the block.
We have read it. But first, whether the suit is maintainable or not.
My lord. That aspect, my lord.
Hmm. No, this is the difficulty with some civil matters in Qatar.
My lord.
Instead of coming to Guwahati to take recourse to a proper, easiest way, go to the neighboring municipal court, file a suit. Hmm.
Lord, I'll reserve my comment for that. Only thing, my lord, in rescue
But
of,
you have to satisfy it.
my lord, section 79 at best. CPC
Section
79.
What is section 79?
Suit by or against the government. There is a provision for that.
What is a suit first?
My lord, of course,
By and against the government will come subsequently.
Well,
What is a suit?
my lord, of course, in a suit, my lord.
What
we
is a
seek-
suit? No,
we
no.
seek for declaration, my lord. The
No, no.
declaration.
Declaration is a only a relief sought for.
My lord.
What is a suit?
Here, basically, my lord,
No, first tell us what is a suit. Read section 9.
section 9. Courts to try all civil suits unless barred. The court
Oh.
shall, subject to the
Suits of
provision.
civil nature. What is civil nature?
Here, what I
No,
understand.
no. What is civil nature? No, we are asking these questions. In the morning, I expressed one view must have.
Well.
A man files a civil suit for promotion.
My lord, educational matter.
Ultimately, the man died. He did not get anything.
Well.
Okay. Today, another matter came. He's filed something for some appointment.
Seniority, yes,
Ah.
I heard.
For the last 10 years, the man is not getting appointment. One suit. So therefore, we are asking, shall have jury try all suits of a civil nature.
Well.
What is a suit of a civil nature?
My lord,
Let us understand what is a civil nature suit.
Well.
Because this is apparently a matter of a legal right of this petitioner being violated by an administrative authority. So it's a matter of
220.
within the jurisdiction of administrative law. 226 straight away we would have issued a notice, asked a question, why are you digging somebody else's land? What authority you have? If you have, show us. If you don't have, stop it.
And had it been for the fact that there alongside the government of
Number one.
someone would have been there.
Number one. Number two, you are claiming your right, title and interest. So who is disputing your right title of interest? Is it your stand somewhere that a BDO is coming and saying that this is not your land?
That actually is the stand. In the proof,
No, stand is a whatever you are, utter or you write. Stand is not something.
but basically the suit is on that parameter itself. That the video has
I understand.
initiated.
So is it a suit of civil nature?
My lord, in so far
Yes.
as
Why did the BDO dig this pond? Why did the BDO dig this pond?
Lordship, it was the predecessor of the present plaintiff and other person, Lordship, executed a gift deed in the year 1948.
Gift deed
Lordship,
to whom? To the
in
BDO?
favor of the government,
Government.
local body, in favor of the local body. That deed was challenged in the earlier round of litigation after 30 years in the year 1991. That suit was dismissed. Appeal dismissed, second appeal also dismissed. Pertaining to same plot of land. But this
Okay,
is only a part.
originally it belonged to the plaintiff, but his
Plaintiff,
predecessor,
predecessor
and but there is a gift deed in favor of the government.
Lord.
And the record of rights had been corrected.
Lordship,
Now it's a government land.
and after second appeal, Lordship, only a part of the land carved out and I'll be present by the present. He is the Lordship, son of the plaintiff number 2 in the
Now this digging is over that part of the land or different?
no
Different.
land.
You say a part of the land is theirs after the second appeal. This digging is taking place in that part of the land or in the rest of the land.
As a whole
Whole.
plot of the law.
So they have a right.
question of evidence, my
No,
lord. The
Lord-
suit is at a preliminary stage.
Lordship, in earlier suit, there are 13 katas, 1 bigha.
But these are done for the public interest. Normally, suit is always in the private interest. So therefore, you go for a suit where public law remedy is not available. But here your public law remedy is available. You
My lord, I obviously being an officer of the court, I'll have to, my lord, stick to the legal parameters.
but
Here,
who will determine this matter? Number one. And they have rightly raised an objection that this was already decided. So now,
Well-
what has been decided is again thought to be redecided.
perhaps not the actual position, the factual position is perhaps a bit different.
But why should the civil court go into all this?
Lordship, kindly have a look at the pleading in their earlier
Forget about
title.
that
Earlier
reading.
kindly have.
Now, what is a suit of civil nature? Tell me that.
My lord, once there is a clouding of right title interest
No,
of
no,
someone,
no one is clouding.
my lord, here
Clouding is a word has almost no meaning in law.
I understand what is calling from your lordship. I am
Clouding has no meaning in law.
here. Well, only thing, my lord, that I could grasp is that the suit has been filed all against the government official. Had there been any initiative on the part of any private
The
individual?
cause of action is that they are digging a pond over a plot of land. Your case is, this is your plot of land. Right or wrong, we don't
Yes.
know. So, the remedy will be in the public law remedy,
My lord.
that stop this. Either you acquire by land or you, if you want for any public purpose, no. Now, you are trying to raise a claim that this is my land.
Yes.
Clouding. So that means your title is not clear. Going by your own word.
Because-
Anything cloud is hazy. Cloud means it's hazy, you cannot identify.
For which I am seeking a declaration.
You are seeking a declaration. Now he says that this declaration is already made against you.
According to him,
Ah.
that is what he's saying.
Ah.
And we say that the declaration that was made earlier in respect of the land of that earlier suit, that does not include the suit land, which is the matter of.
So where is your averment to that effect?
My lord.
Where is your averment and a fair declaration that there was earlier a declaration against us
Well.
regarding this thing, but that declaration is in respect of this land, this is in respect of another land, so it is not covered. Where is that statement?
My lord, will come to inner page. My lord, the pagination is not available with me. From page 54, the plain search, according to my learned friend, so it has to be 54.
Mr. Mojumdar, why don't you give him a paginated copy? Give him your
My
copy.
lord, that's all, 56.
It's not online. We are hearing you 3 or 4 times repeating the same thing,
Well-
not paginated. Why should I hear those words from you?
My lord, I am.
And now you are saying when you raise the question, that's all right.
My lord,
Then don't utter that word.
my lord.
If you want us to go into the question, not paginated, let me ask him the question.
well.
And if you don't want to go, please don't raise it.
My lord, it is not.
Either of the two. You can't have benefit of both.
My lord, it's not paid.
Then you want to get it paginated. Get it paginated then. Next. No.
On that day, my lord, your lordship,
Come to produce a copy of a judgment dated 111 in RSA 175. No, no. Why? What is the relevance of that judgment?
my lord, I.
You are
pointed
for
out
the
to you
appellant.
Substantial question of.
Are you for the appellant?
I'm for the.
You are for the respondent. So it's a concurrent judgment or
Concurrent, sir.
concurrent? Concurrent against you.
Yes.
You are the plaintiff or defendant.
I was the, actually, my lord, petitioner. Because,
Petition.
my lord, this appeal arises out of a misday case. Because misday case was filed under Order 21, Rule 97-100.
Sorry, just a minute.
Right.
Who is the plaintiff?
My lord, I'm not plaintiff, I am petitioner.
You may not, you may be anything, but who is the plaintiff?
My lord, it is not the title suit, ma'am. Your lordship.
It is not a title suit.
I want to clarify, because my lord, original petition was filed under Order 21, Rule 97, 100 and 101.
2197.
Yes.
Who is the decree holder?
We are petitioner.
You are the decree holder.
He was decree holder.
And you are resisting.
Yes, I'm resisting the.
You are resisting. So you have filed a petition under Order 21, Rule 97. Then what happened?
Then, my lord, our petition was dismissed by the trial court.
Hmm.
Against that, we filed appeal, my lord. Appeal was also dismissed, and this RSS against that title.
Appeal under which provision?
Appeal under your lordship. Appeal under.
No, where is the order dismissing Order 21, Rule 97 petition?
Yes, I'm here. Your lordship would be pleased to turn to page 25 of my memo.
Of the?
Memo, my lord, memo.
Of the RSA.
RSA.
RSA 193.
Yes, ma'am.
Page 25.
Page 25.
my lord, at the top, my lord, meet the case number 65 of
Mhm, mhm.
2012.
Yes, sir.
Now, my lord. Thank you, lord. Yeah. Thank you.
What happened to TS 21 2012?
That was withdrawn.
Withdrawn.
Yes, my lord, as per direction of your lord. That may be withdrawn. I said, yes,
Which,
maybe withdrawn.
which page?
My lord, that your lordship would be pleased to page 26, my lord.
No, 26, I have read it.
CRP,
No, no, you said at the direction of the court. Where is that order? Why
my
will
lord,
the court
direction
issue a
of the
direction?
court, my lord, that CRP order thing.
Hmm?
In the CRP, my lord, an order has been passed by your lord.
Where is it?
Yes, my lord. I'm-
CRP against the rejection of the petition under order 20.
Where is the CRP?
I'm giving.
Yes, 21.
Over. Where is the High Court judgment? This one?
That RSA, my lord, RSA judgment I have given.
Not RSA, that just
CRP.
CRP.
Yes.
What is this order? MH that the petitioner decided to withdraw TS 2112.
Yes.
And the offshoot proceeding therefrom in this court extend liberty to file afresh under 2197 and 101.
Yes.
Taking all grounds. It is your decision to withdraw.
Yes.
There is no direction from the court to withdraw.
No direction.
Then why did you withdraw?
This, my lord,
No. Why did you withdraw?
I have withdrawn, my lord. That there
No,
is remedy.
Mr. Sheikh. We have put this question not to question you, but for a particular purpose. The decree that is sought to be executed, which you are trying to resist, is not a decree where you are involved.
No, my lord. That is why
Huh?
the land in question, I am also in possession, the petitioner. So, my lord,
Mr.
what happened? We are
Mr.
not party
Sheikh,
there.
difficulty is you are not understanding the question in the true perspective. In that original decree, which Mr. Sigdar's client is trying to execute,
Yes.
was the present petitioner a party there?
No.
They are not a party. So, is this decree binding on you? If you are not a party, is this decree binding on you?
No.
No. Now you come to Order 21, Rule 101. 97 has to be read with 101 always. All questions, including questions relating to right title interest in the property arising between the parties to a proceeding. So y- you are not included in the term between the parties in the proceeding.
Let us first read.
No, don't read first.
Madam.
First answer. You are not a party to the proceeding.
Yes.
If you are not a party to the proceeding,
Madam.
any question regarding right title and interest in the property arising between the parties to a proceeding.
So, my lord, 97
Between
will
the
come.
parties to a proceeding on an application 97, relevant provision shall be determined with a.
They are
So-
representative.
So now,
Or they are representative.
no, you are claiming adverse possession against the defendants or against the plaintiff?
Against the plaintiff.
Plaintiff.
Yes.
And plaintiff has got a decree in his favor that it is his land. So prior to the decree, your adverse possession is against the defendants or against the plaintiff?
Against the plaintiff.
Plaintiff.
Yes.
So now court comes to a finding that petitioners were not necessary parties in PS 112. PS 112 was ultimately decided in their favor. So this is the judgment in the order 21 rule 97 petition. This is the judgment rendered in order 21 rule 97 petition. After this, you went in appeal
Appeal,
as first appeal.
misappeal. That was registered as misappeal. Misappeal under section 96 of the city. The court of civil justice.
Miscellaneous appeal.
Yes.
Then why this is RSA then?
Yeah,
No. But, where is that appellate judgment? Page number?
sorry, my lord,
Appellate judgment, page number.
appellate judgment.
Page number 50
Yes,
something,
sir.
I think, no? 50, 49,
47.
47.
36 onward. 36 onward. Yeah.
There was two.
Just.
It starts from 50 meters.
Mr. Sheikh, please, who filed this appeal? You filed or he filed? You filed.
I filed.
We come to page number 50.
50, yes.
First line.
My lord.
This appeal under section, not section actually, it should be order
It should be order.
43 rule 1.
My lord, that is my first substantial question of law raised before your lordship. This is wrongly written because your lordship would be pleased to see the appeal.
Where is your memo of appeal?
Yes, my lord. It's a second, first appeal matter under section 96. It was first. So, my lord, it is actually
Because, Mr. Stigdar,
wrongly.
this will have to go back. We'll have to set aside this one, let it go back. Because this cannot be an appeal under order 43 rule 1. Because if you come to order 43 rule 1, please take the CPC. Please read the order 43 rule 1.
43 rule 1 appeals from order.
An appeal shall
appeal
lie
shall
from the following orders under provision of section 104. Read
Or-
it.
An order under Rule 10.
No, it does not include a order passed under order 21 rule 97 read with 101. There is a reason for it. Order 21 rule 101 says that an application resisting the execution of a decree will be decided like an independent suit. That language is there. You come to all questions, including questions arising between the parties or proceeding on an application under rule 97 or 99 shall be determined dealing with the application not by a separate suit, and for this purpose court shall notwithstanding any primary deemed to have jurisdiction to decide. So it will be decided as if it is a separate suit. As it is a separate suit, it is a judgment in a suit. So therefore, appeal will be first appeal under section 96. And he had rightly filed it, but the court deemed it that this is an appeal under order 43 rule 1. So we'll not do anything, we'll send it back, ask the court to determine his appeal as if it's an appeal under section 96.
And their memo is mentioned.
Memo also he writes correctly, that's why I checked up. Otherwise, I would have asked Mr. Sheikh that why did you write it? He writes appeal under 96, read with order 41. But it is the court who thought, and there is a reason why the court thought. You please come to page number 25, I think. 25, see on the top, the court writes as final order.
Right.
So court must have thought that this is an order. And section 104 and order 43 rule 1 is an appellate provision for orders. Whereas 96 and rule 41 are appellate provisions against judgment and decrees. So merely because the word order is written, the court must have thought this is an order. And there will be difference in perspective of the two jurisdictions. So let it go back, correct it. And we are saying we are not observing anything on merit. And one further question to be determined is, in the application under order 21 rule 97, his claim for adverse possession was rejected, saying that there is no documentary evidence. Will an adverse possession ever be stamped and documented by any authority?
They have to make out their
Mr. Sikdar, tomorrow you go and occupy Mr. Sheikh's house. It will be a question of fact. Do you expect your occupation of his house will be documented and stamped by some authority so as to produce any documentary evidence, or it will be oral evidence?
my lord, they have no material. But we have the material that we are Kotian holder, we are the successor of.
Mr. Sigdar, you are yet to understand the concept of adverse possession. Adverse possession, you are the owner, but he is in occupation without being an owner.
There is another point. So for the adverse possession,
You argued out in the
Yeah.
first appellate court. Heard Mr. M. A. Sheikh, learned counsel for the, this is what? For the appellant. Also heard Mr. E. S. Sigdar, learned counsel for the respondent. The respondents are the decree holder in respect of a judgment and decree dated
my lord, that has been noted in RSM.
judgment and decree dated. What is the date?
My lord, page 25, my lord. 17 September 2009.
17? No.
Your lordship.
No, this is the order passed in order 21 rule 97 petition. What is the date of your decree you are seeking to execute? Dated so and so in TS 512/2003, which had been confirmed by the judgment and order dated 1/11/2011 in RSA 277/2011. Accordingly, for execution of the decree, title EX execution, case number 3/2011 had been instituted by the respondents in the court of the Munsif Bilasipara at Dhubri. The present petitioners claiming adverse possession over the suit land involved in the decree in favor of the respondents filed an application under Order 21, Rule 97 and 101 of the CPC, read with Section 47 of the CPC, resisting the execution of the decree. Order 21, Rule 101 makes it explicit that an application under Order 97 or an application under Order 21, Rule 97 or Rule 99 shall be determined by the court in respect of all questions, including questions relating to right title or interest in the property arising between the parties, and not by a separate suit for the purpose. Accordingly, it has to be understood that the application under Order 21, Rule 97, read with 101 and Section 47 of the CPC would have to be understood to be a proceeding in the nature of a suit. The application of the petitioners under Order 21, Rule 97 and 101, read with Section 47 of the CPC, was rejected by the order dated 17/9/2019 of the learned Munsif Bilasipara Dhubri in Ms. J case number 65/2012. on dismissal of the resistance to the execution of decree under Order 21, Rule 97 and 101, read with Section 47 of the CPC, the appellants instituted an appeal under Section 97, read with Order 41 of the CPC, which was registered as Miss Appeal 16/2019. The Miss Appeal 16/2019 was determined by the learned appellate court, being the court of the civil judge Dhubri, by the judgment dated 4/8/2022. The very first paragraph of the judgment dated 4/8/2022 provides as extracted.
Highway. Page 50.
Please correct a little later,
Right here.
not now. কি করলো? So, makes it discernible that the learned civil judge proceeded with the appeal, understanding it to be an appeal under Order 43, Rule 1 of the CPC. Order 41, Rule 43, Rule 1 of the CPC is extracted as below. A reading of the circumstances provided under Order 43, Rule 1 a reading of the representative in respect of which order an appeal will lie under Order 43, Rule 1 is provided therein from subclauses A to W, comma, but a perusal thereof, no provision is found that any order that may have been passed in an application, any judgment or order that may be passed in an application under Order 21, Rule 97, read with Rule 101, that in respect of an application, in respect of an application under Order 21, Rule 97, would also be included in Order 43, Rule 1. Further, as already expressed, Order 21, Rule 101 requires that an application for resisting a decree would not be decided in a separate suit, meaning thereby the same itself would be decided in the manner as if it is a suit of its own. As the determination of an application under Order 21, Rule 97, read with 101 requires it to be decided in the manner of a suit. It is for this reason that any order passed in such application is not included in the orders that may be appealable under Order 43, Rule 1. We have perused a memo of appeal, which in Miss Appeal 16/2019 of the petitioner, wherein the petitioner is specific that it is an appeal under Section 96, read with Order 41 of the CPC, and not an order under Rule 43, Order 43, Rule 1. As the appellate court had proceeded in a manner, not to be an appeal under Section 96 read with order 41, but considering it to be an appeal under order 43 rule 1, we interfere with the judgment dated 4/8/2022 and remand the matter back to the learned civil judge Dhubri for a fresh adjudication by considering the appeal instituted by the petitioners to be an appeal under section 96 read with order 41. Both the parties to appear before the learned civil judge Dhubri on so and so.
Develop.
LCR has not come.
But
mean,
may I point out this correction, madam. It will be fifth of August,
Hmm.
not 4th of
A
August.
judgment dated 5th of August.
And another. Regarding this.
We are
degree-
clarifying that
degree,
the
my lord.
interference of the judgment dated so and so in this case is not on any of the issues that may have been decided on its merit, but on a technical reason that the appeal is to be given its consideration as an appeal under things. And it will be open for the learned civil judge to decide the appeal in any appropriate manner as may be advised.
Your lordship pointed out regarding the judgment and degree of the original court, that is 9/3/2009.
9/3/2009
2009 entitled suit number 11.
Entitled, sir? which was confirmed by the order dated so and so in RSS so and so. এইটো লৈ ল'ব।
Much over.
Item 12 for hearing.
This is your lordship. Lordship. Respondent number 1 and 2 have expired. As such, we have filed a substitution petition along with 2 other IAs, which have not been tagged,
It stated that the respondent number
1 and 2.
1 and 2 died in the meantime, and application for substitution
And 1.
setting aside of abatement
Suddenly,
as well as condoning the delay had been instituted, which is not on record, raised to list along with such applications.
Time being item 1.
এইখন হেৰিক দিব লাগিব মিষ্টাৰ শেখ MS শেখ ক'ত গ'ল এই তেওঁক দি দিয়ে বেগমক দি দিয়ে
may I please give my lord,
withdraw
in this matter, my lord,
want to withdraw
yes, but when he has died, my lord, he doesn't have any legal heir. So it is awaited, my lord. So
petition appellant died
yes,
he does not have any legal heir so what will be the position of law
my lord, it will be awaited, my lord. There is nothing because they have already got the decree, my lord, from the law. Because it is her son's property, which he has gifted to third party. And
son
that was
also no more
no more. Both the son died. Mother, his daughter-in-law is there. She has given the affidavit that we are not interested to contest it.
where is the affidavit
My lord, actually, he has sent it with today, my lord, but I have not received yet.
I think we need to bring it on record
I'll read it,
Mhm.
my lord, let it be.
It is stated by Mr. K. Chatterjee and counsel for the appellant that during the pendency of this appeal, the appellant had died. And except for a daughter-in-law, there is no other legal heirs, and the daughter-in-law had also
So an affidavit.
sworn an affidavit. Mr. Bhattacharjee,
Yes.
I think has to be done in 2 steps.
If I write it,
The daughter-in-law will have to get substituted in place of the appellant.
but he is not interested, my lord.
May not be. Just
yes.
she will have to get substituted, and then we'll take note of her affidavit. She is not interested to pursue the appeal, and we'll close the appeal. That will be the correct procedure.
So,
But now, on whose statement, on whose behalf I'll close this appeal? It cannot be Mr. K. Bhattacharjee.
No, my lord, I have the death
Eh,
certificate. I
And the
agree with-
person is no more.
No, I agree with that, my lord.
So
So
that will
once
be,
I get the affidavit, I will.
that would have been the actually the correct position.
Yes.
Daughter-in-law get substituted and
Because
then
she's not willing to sign any paper. That is the question, my lord.
do whatever you do. I am not interested.
The one for the number one.
Also,
The content. He had also expired on 8/4/2016. Otherwise, also
How many respondents are there? More than one.
more than
But the appeal will remain. Only against one it will abate. Had it been the sole respondent, that may have been an easier way out. Don't take note of Mr. Bhattacharjee's statement. Take note of your and close it. What to do? You think over.
I will file the
Because every petition can be closed on the statement of a party.
But my only submission before lordship is that since my plaintiff has died, I have no power to represent her.
Huh.
And so the new substitute which I am going to mail, they have to swear the affidavit, but they are reluctant to sign any paper. That is the question. I can only produce the affidavit where she has categorically stated that
But we can't take note of that.
I file a copy, my lord, along with the petition. Because I cannot plead, my lord, on behalf of the plaintiff.
We can do one thing. We can record the statement of the counsel for the defendant that to my knowledge, appellant is no more.
No.
And then record statement of Mr. Bhattacharjee that Mr. Bhattacharjee has also
Acknowledge.
stated that he is no more. If it closed.
That can,
that can
I think that will be,
I think that will be for your lordship. as
that
correctly.
will be permissible in law.
as per my instruction, my lord, the appellant has died on 15th.
Whatever it is.
Just before the puja, they have confirmed
This puja.
this puja.
Died earlier.
Because they are very poor people, my lord, they labor class. So they don't want to go in the court. I repeatedly asked her daughter-in-law, you sign the paper.
No,
give the
tell
voter-
her we can request Mr. Bhattacharjee to act as an amicus henceforth. And she doesn't have to pay also. We'll get your that nominal amount as an amicus.
Not-
We can arrange for that.
My lord, that is okay, my lord, but she is not willing to pursue this matter because they have settled it amicably between the parties with the legal heir of the respondent.
Then let us take this
That-
statement.
that-
Your name, please.
DJ
Mr.
DJ
G.J. Saikia. Land Council appearing for the respondent number.
One.
One is died.
One.
Do you appear for the other
Yes,
respondent?
others I don't know, but yesterday itself I have got the power legal of filing that.
Substitution he will file, you will not file.
That I-
Why do you want to get yourself in?
No, no, only document I have. As of that,
Land Council for the respondent number one has made a statement that the appellant died on
15 feet.
Yes. Died on 15/3/2020.
15/3, appellant died on 15/3/2022.
22. 22.
22. 15/3/2022. Mr. K. Bhattacharjee, Land Council, who appeared for the appellant, also confirms the statement that the appellant's Sahatior Tior is no more. As no legal heirs of the appellant is coming forward, the RSA 185/2016 is closed. However, providing liberty to the legal heirs, if any, if they approach, to be determined as per law. I think this much we can do. If they come, we'll see to it.
Because I don't have the power to.
Definitely. But you can confirm the statement that your client is.
I
That,
will convey.
that we can record it.
Obliged.
3 and 4.
Mr. Chaudhary did wait for a long time. He must have gone somewhere else by now. Is he available nearby? RKD Chaudhary, just see. If he's there, we'll call. Otherwise, we'll fix a date. That is. Arwa Sen ji. Phone to hey, check it out. Mr. RKD Chaudhary, is he?
But it is late.
No, RKD Chaudhary.
But supposed to there is
Where is Mr. Chaudhary? Is he available?
Right, right.
Just see, if he's available, we'll hear him. If he's not available, we'll fix a date. Mr. Chaudhary is coming. That matter, 86 and 84. They can be done.
If your lordship will come to section 86,
86.
because this was an order passed by the summary powers of a summary court. If I may take your lordship to subsection 4,
Let
Yes, somebody-
me read when there is
One
no
and
grave reason
one
for
and
immediate.
right, Mr. A summary force court may pass any sentence. Lordship will mark the word sentence.
Uh,
Sentence in
No. We're trying to read the whole thing.
Yes,
Just
yes.
subject to the provisions of subsection 2, summary court may try any. When there is no grave reason for immediate action, no grave reason, and reference can, without detriment to discipline, be made to the officer empowered to convene a petty court force for the trial of the alleged offender. An officer holding summary court shall not try without reference any offender section or any offender against officer holding. 1619,
1619.
49, what are they?
Offences in relation to enemy and punishable with death. That is
16 is officer relation to enemy punishable with death, mutiny, and
19 is mutiny
49 is
and 14.
49 is civil offenses.
This is not that.
Shall not know civil offense subject to the provision section 50. Any person subject to who at any way commits any civil offense shall be deemed to be guilty of an under this act if charged thereof. This section shall liable to, and if charged section civil offense. Civil offense is defined. I read it earlier.
Civil offence is at 49.
No, civil offense is defined in the definition.
Yeah.
I think I have read it
See,
earlier.
2C.
2C. Civil offense means an offense which is triable by a criminal court. So just a minute. So no, I know the rules. I've read it earlier. Civil offense is an offense triable by a criminal court. Okay, because in this forces, they distinguish between the criminal court and their immediate distincts, things like mutiny, these, that.
Yeah.
These are within our purview. No one should come in between. So when it is a regular criminal case, criminal offense, it is a civil offense.
It's a civil.
Which is nothing to do with the forces. That is the whole thinking. So civil offense means tribal by criminal court.
Criminal.
Okay. Now if you read, and 49 is civil offenses.
Yes.
Subject to the provisions of section 50, any person subject who at any commits any civil offense shall be deemed to be guilty of an offense against this act, and if charged therewith under this section shall be liable to be tried by a force court. This is what I was trying to come to.
Yeah.
So when a member of the force fires 6 rounds through his service weapon, it is a civil offense because that may cause violation of many of the otherwise criminal offenses, which are normally triable by a criminal court. Had he done something different, it's okay. Suppose the commanding officer says, like sometime back we had this thing, don't go out of the premises and visit the local market. Sometime back I had one man always goes out, sneaks out, goes consume some liquor in some local market next to the cantonment area, comes back. This is not a civil offense because it is not triable by a criminal court. But the act of firing by a gun will be a civil offense. If it is a civil offense, it is 49. 49 says shall be liable to be tried by a force court. So therefore, it will be section 84.
Okay, may I? As I have. No. If we read.
No, we requested your presence because earlier the office, no one was ready to listen anything. Only submission coming is we have followed the law procedure. That is another aspect. And no one is saying that you have not followed the procedure adopted. But whether the procedure adopted is
Right.
appropriate or wrong.
What?
Pass any sentence which may be passed under this act, except the sentence of death or imprisonment for a term
Now.
exceeding the limit.
Now the limit is
1 year.
1. And this
For if the officer holding force court holds the rank not below a commandant, and 3 months if distinct. So a summary force court may pass any sentence which may be except the sentence of death or a term limit distinct. So if it exceeds this limit, it is not summary force court.
That is what I was trying to. What I have, if your lordship will read, the summary force court may pass any sentence. Now, what is the sentence in it? Sentence would be an imprisonment or a fine, which there are provisions here. A person can be to imprisonment also. But the order passed is in the nature of a disciplinary proceeding. It's a penal. It's not a sentence.
No. Where is the allegation? Let us read. Mr. Padgiri, in which page of the petition, the allegation? that you have fired 6 rounds and those things. In which page is it?
It's a page 26, annexure 5.
Page 26.
Initiative.
Where is the arms arm section? So firing of weapon is not an offense or what? For the armed forces.
Not included,
Hmm.
is not included. What I was taking your lordship,
Hmm.
37, what is the charge?
What is
Charge against him. Lordship will find a page 37 the writ petition.
37. So 27 of the Arms Act, whoever uses any arms in contravention of section 5. Section 5 is license. So are the armed forces licensed to fire their arms at any time they feel like? So then license, what is license is in the nature of permission. You use the arm. If he is firing merrily in the with his weapon, is he not committing something against what he is entitled? So is he not violating any?
That should have come.
It-
That should have
No, we are little concerned. Maybe the punishment on this man will be increased also. That possibility is there. But suppose one man is firing in the air. So what do? Just dismiss him. Don't show your face from tomorrow again. But what about the act of misusing a firearm? Firearm is a serious issue.
Yeah.
So tomorrow one man may feel that I'll be only dismissed. He had already made arrangement for some many other alternative, better way of living. Let me misuse the firearm and go. Is he not liable for that act?
That should have,
And mind you, section 27 says minimum 3 years. So once it is minimum 3 years, 87, 4 and 5 years are also taken care of.
now, if your lordship will see, he has been charged under section of the, at page
37.
the
Open fire in an irresponsible manner.
if we see section 43, because it is given a heading violation of good order and discipline. Violation of good order and discipline is section 43. Now, what is the punishment prescribed? Any person subject to this act who is guilty of any act or omission which, though not specified in this act, this firing lordship question is not there, is prejudicial to the good order and discipline of the court, shall on conviction by a force court.
But
be-
again, this is again a conflicting situation. The moment this man is charged under 43, it is force court. It
If-
cannot be summary court.
by a force, no, there is a general force court, there is a petty force court, there is a summary. There are three force.
So this force court has to be.
Now,
Hmm.
that is lordship will find it section 63. General force court, it is convened by 5, not less than 5 officers.
So now, another kind of inconsistency. Somehow, Mr.
There is inconsistency. That is what
Mr. Chaudhary, somehow we are not finding it convincing. I don't know why. In your mind, sometimes tells you something that possibly it's not in order. Now, by force course, so you are charged him under 43.
he has been charged under 40.
43. Once he charged under 43, on of the force court shall on conviction by a force court be liable to suffer imprisonment which may extend to 7 years or such less
Yes, sir.
punishment as mentioned. So now, if you subject this section 43 man to a summary force court, okay, I accept you that there are,
Conviction and imprisonment. That was what I was coming. It is
understand,
conviction, sentence. Sentence means imprisonment.
no, sentence.
Sentence will be imprisonment
Ah.
or some fine. Here, lordship will observe this is a dismissal from.
This is what we are trying to say.
No, that is
This is what we are trying to say. Moment the charge is section 43, this man is liable to be sentenced anything up to 7 years or less.
Yes.
Who will take that decision? Just a
Well,
minute. No.
summary court will not.
No. Who will take the decision? The force court will take that decision.
Force.
Now, in view of 86, 5, 4 and 5,
It cannot be more than
no,
1
if
year.
you are subjecting him to the summary force court, that means the person who had used the discretion to refer it to the summary force court had already taken a decision that this man will not be sentenced anything beyond 1 year or three months, as the case may be. So a decision which ought to have been taken by the force court now had been taken by the authority who is using the discretion to refer it to a force court.
That is what I was coming. Summary court, it did not have the power beyond 1 year.
So had 43 not been there,
43 says 7 years or less, that will be, if it is 7 years, then it will be the general court. Then it will be the general court. And on the other side,
no, this is what, whether it will be 7 years or 1 month, I am taking both the extremes. This decision will be taken only by the force court.
Yes.
And the force court may be either of the three force courts. This general, petty, and summary.
Yes.
Now, the authority who is taking the decision that refer this man to the summary force court, he had pre-decided that the sentence against this man
will not be more than 1 year.
will not be more than 1 year. How that, whether that man is authorized to take that decision? That decision will be taken only by the force court.
No.
General force court may send it back to summary. That after looking at preliminary, we are of the view that this doesn't call for any sentence beyond 3 months. Send it to the summary. But the officer who is referring to the force court has no jurisdiction to take that decision. And by taking a decision that you refer it to summary court, he had precluded the force courts from taking any decision to make the sentence beyond 1 year or 3 months, as the case may be.
What is more interesting here is summary court consists of only the commandant.
I know.
Now the commandant, he cannot refer it to himself. He takes it. And whatever seen the order, this is not a conviction as a sentence.
Dismiss.
This is a dismissal. Dismissal will only, it's a disciplinary procedure. It need not go to a court.
You know, go to a force court also
It need
possibly.
not go to a court.
He could have said, instead of making a charges under section 43, he could have said that your act of hiring the ground is a case of gross misconduct. I'm initiating a disciplinary proceeding against you.
That is, but so far as summary court as your even I have got my doubt because occupancy it cannot be put here. And in fact, this is not a sentence.
May not be. The sentence may have been no imprisonment. When the court had passed this order, this sentence is no imprisonment, only dismissal. Suppose we take it that way also.
But that
Still, somebody without authority of law had already taken a decision that in spite of the charges under 43, this man will be given punishment of only less than 1 year or less than 3 months.
that is what has come to mind. Is some inconsistency.
Something is there. I don't know. I've been hearing this for almost 10, 12 days now. Something is not,
It is not fitting in.
it's not fitting in.
It's not fitting. If 43, then this cannot.
So he could have very well desisted himself from invoking 43.
Refer it.
If he invokes, you refer it to the authority who will to take the decision. If he does not invoke 43, he could have said that this is an act of gross misconduct.
That
Not a case of 43.
That is another act. That will be a normal disciplinary
Normal discipline, then normal discipline.
penalty.
Then you can dismiss him.
Yeah.
That the misconduct is of very serious nature, we don't want to retain you. Go.
language of the act is conviction.
Hmm.
That
But that is the discretion of the force court, whether you only take a disciplinary action or you also convict him. It's a discretion. But again, that is the discretion of the force court, not of the authority referring to the force court.
if 43 lordship, then it has to be,
43 has to be.
no, as it is on record, it is 43.
Hmm.
43, maybe the summary court could not have.
They cannot.
I,
Because-
sorry to correct, I have not.
No, because suppose the High Court rule says if the value of the suit is 2 lakhs, it will be division bench. And if it is 1 lakh, it is single bench. Chief Justice as the master of a roster cannot send it to the single bench. Then on the administrative side, he will be taking a decision that this value is less than 1 lakh, so I am sending it to the single judge. He cannot do that. Similarly, the referring authority has no jurisdiction to take a call of what will be the ultimate. He will only referring authority. Yes, I have come across this case. I'm referring it.
Because
Take your decision.
summary court is a one-man show, basically. He,
Summary is what you know. The man will be sitting in his office. Other man will be bound and kept somewhere in some corner somewhere. Whenever the officer feels like somebody reminds him, oh, that man is there, yes, call him. After calling him, he'll ask him, hey, what is this going on? Firing and all. What do you have to say? The man will say, please forgive me, I'll not do it again. The summary court will say, dismiss. End of the proceeding.
however, they have given some evidence that it not good. But
What do you suggest? You tell us, you take your time. We'll have it.
lordship will give me one day. I will.
And that's why I'm thinking, because
But prima facie, there is some-
something, because when I heard first, something is,
they might be following all the procedures. But if you invoke 43, perhaps summary
somebody will not be maintainable.
will
Participant by in section 51, describe punishment 51.
Hmm.
not such.
The dismissal or removal
That is there. But it may not be by the summary.
convicted by force court. Court in a scale of
It is there. It could be like,
systematic student.
yeah.
Point of a decision on the Army Act, only one line as set out. Section 71 is not applicable to SCM, but only to a GCM. I don't know what is section 71. Is it something in the nature of section 43 of this matter?
is referring to the
Just is pointed out some Supreme Court judgment. Just see para 15. Some similarity appears to be there. Read para 15 of that one. Something of same that some powers of summary court martial and general court martial. I have not read the whole judgment. I just picked up a few lines.
part referred to UP.
Huh. Same is here.
Same is
That 16, 19 and
read in the aforesaid context of section 4 of section 20 clearly says that the SCF summary court can pass any sentence as contemplated under the act except for a sentence of death or deportation or of imprisonment for a term which may exceed a period of 1 year for an officer of the rank of head.
that same as your 86.5.
Quite clearly the aforesaid provision is not applicable. The
Hmm.
says quite clearly the aforesaid provision is not applicable and cannot come to the aid of the PCM or a summary court martial up to a
I don't know. I have not read the whole. You take a copy with you. You go through it also. But ultimately, the same question will remain in our case. If he is charged under 43, can you restrict him to a summary court?
that was what I
Hmm.
so I pointed maybe that has to be
We'll hear you on one day because this may have some bearing on these proceedings also. No? Means I just don't want to impose a order.
what was striking me was it had been a simply a disciplinary procedure, normal.
Hmm.
Things would have
Then
been
it's
otherwise.
okay that even we would not have been concerned.
Once referred to a court
Hmm.
and you are invoking a section,
Hmm.
that has to be
He has assumed a jurisdiction which he did not have possibly.
43 clearly is beyond
43 is creating all the problem. But Mr. Padgiri, if he decides this, immediate relief of sending back, but your client will be in more trouble than what he is already in. You take your call whether you want to enter this question arena or not. What your client is possibly having, he'll be in a even a more worse position. You take your call. If you say I am not pressing with this thing, it is another factor. But if you press, we'll have to go to this question. If you go immediately, it will be set aside, referred. But thereafter, along with dismissal, you may be imprisoned also. That possibility is there. So your client may come back tomorrow at you that what did you do with my case? Hmm. Only technically we are finding something, but impact may be even worse against you. Think about it. Mr. Chaudhary, I think the impact will be even worse against this man.
it goes with
Just one. I've not read the whole thing. I just let's not get confused with that. Take our own case.
Unauthorized deed.
Yeah, notice that.
This lordship, whatever is there in my mind, let me take it up with them. Perhaps they are misconstruing between a penalty, punishment, and a sentence.
Hmm.
Because
And frankly speaking, summary court, as the name itself appears, see, summary is even lower than a petty.
Yes.
So the allegation must be
below,
below petty, then only summary.
yes,
And firing 6 rounds today, your weapon is it's above petty.
like a note has been given to me. Authority,
Mm.
just like it has fallen from your line. Things are.
For the last 10, 12 days, the only submission getting, we have complied with everything.
I was talking to my friend.
Madam Devi.
Suddenly got my that book. It's a sentence to be 1 year, 3 months.
Hmm.
So I said, "Oh, there is
Something is there. Sometimes what happens when you keep on hearing, things don't fall into place. When they don't fall into place, at least I find it very difficult to take a call. It will be a half-baked order. Maybe favor, maybe against, we don't know, but it'll never be a correct order. But Mr. Patigiri, take note, your client may be in more trouble if you allow this petition in this manner.
Just,
Hmm?
it's just along.
Otherwise, on merit, have you taken any ground that they say we have followed all the procedure? Do you have anything to say that procedure was not followed?
Yes.
Nothing is there. You have no such
admitted
ground.
everything. He has pleaded guilty.
Sorry.
He has
Pleaded
admitted
guilty, yes.
everything, he has pleaded
Hmm.
guilty. So
Madam Devi was saying that he had already pleaded guilty.
only the forum.
Hmm.
Which could be.
Think about it. He already heard in part, I think, this one. Heard in part. But hearing to continue on.
Can it be on next? Monday, Tuesday.
Okay, next. But here almost agreed.
It's not the agreement, lordship.
Not the agreement,
I-
as you
what
see
I
the rules.
seen, lordship.
Hmm.
That is what has come to.
Hmm. And you
I
think
hope I am not.
it appears so. And somehow I am finding it very inconsistent that a matter of such a serious nature will be decided in a summary manner. That itself is inconsistent. And your middle name clinches it. That petty force court.
Yes.
So summary is below petty.
Summary is below. Has
And if this is tried by summary, so firing the weapons is less than petty.
even if lordship is assumed that commanded heading of the Supreme Court has to enforce discipline. This would be too heavy a burden of
This particular thing, what to do with this man.
Petty also we can.
Think about it. Budwari decision, right?
Item 10.
Yes, this is another peculiar problem, Mr. Chaudhary, although a good thing you are not with the state of Assam. A suit against 3 government officials, one has come in revision, other 2 are still respondents here. Then suit against 3 government officials. For some order, one of the official is in revision before this court. And in the revision, 2 other government officials are respondents.
And they are opposing.
And they're opposing now.
That is not fair. They are direct.
Tell me one thing. Means I want to help your knowledge on the civil law. It's quite often we are getting these things. If you come to section 9 CPC, আসেন কি CPC এখন যোগ করুন।
Well,
The court shall, subject to provisions herein contained, have jurisdiction to try all suits of a civil nature, excepting suits where the cognizance is either expressly or impliedly barred. Express bar, we have some provisions like Guwahati Municipal Act, I think something is barred civil code, and so. Few of them are there. Impliedly barred is another concept which has to be looked into. What is impliedly barred and how it is impliedly barred. Suits of a civil nature, what does it mean? Because in the morning I came across a case, somebody is selected for appointment. One unsuccessful candidate goes and files a civil suit. There is an injunction. Now 10 years have gone by. This man is saying, I'm yet to get my appointment, although I am selected. Sometime back, I came across a matter. Somebody filed a civil suit that he was not given the promotion he is entitled. Suit, appeal, injunction, this, that, everything went on. Matter proceeded for more than about 23 years. Ultimately, the stage of second appeal, the man has retired. Then we are asking him, why are you continuing with it? No, if I get my promotion, I'll get some more pension. So after 23 years, he is brought down to that stage. And civil suit, normally it's not heard on the same day. It'll take some time to hear. In the meantime, that man died also. Gone his case of promotion. Here is a case, somebody claims that this is his plot of land and the BDO comes forward, starts digging a pond there. Digging a pond. According to the BDO, it is the government land because earlier predecessor of interest of this man had given a gift deed. Gift to the government. That gift deed was challenged by somebody, that suit also came to an end, dismissed. So gift deed is valid. This is the stage of the, now he is coming in a civil suit. Is it necessary to give a meaning to section 9 and restrict some kind of proceedings? It's neither leading here nor leading anywhere. So in the suit, the BDO comes and files an application that this is barred by section 9 or 10 because there was a earlier suit. But again, that earlier suit is not possibly against a BDO, may not be the same parties. But the issue was decided that this gift deed is accepted, meaning thereby it's a property of the government. So BDO says, I am digging my own property. The public requires a pond to be dug in a government land, I am digging it.
But not for the fact. But I have got a lot of. I am gifting it to the government. If I have the
Because government gives you on lease.
government gives me on leave. Now, if there is a gift deed, there has to be a tax to be paid, just like a building. Is the value of
That we don't know. That went in the previous litigation between the parties.
if it is not valid, because we cannot give, we can renounce our right, then it goes back to the.
If you are attending the education bench matters, you'll find a lot of such cases. My predecessor gifted the land for operation of this school. Now the school has been provincialized. So give me an employment. As the school is operating in our private land, which was gifted earlier, give me an appointment. These kind of petitions are quite normal in bench too.
If the government. Difficult for
Be
me to
that as it
accept.
may, without going into that aspect, would you restrict suits to some extent by giving a meaning to the expression suits of a civil nature? What is a suit of a civil nature? Again, it's a very wide concept.
Normally, lordship, even
But when the law provides for a definite relief, alternatively, much more efficacious. Say in that case of promotion, he could have come to the High Court under 226 or tribunal. The case of that appointment, same. This matter, easily a writ petition is maintainable that without any authority of law, your administrative action of digging my land is bad. Either you take over my land, requisition it, or give me compensation. We are entertaining. When a more efficacious remedy is available, should an interpretation be given to the expression suits of a civil nature?
very good.
Otherwise, if you look at the concept of alternative remedy in a writ petition, if for every action suit is available, the state can easily raise an objection. Alternative remedy is available. They go for a civil suit. So none of the writ petitions will be maintainable. If I entertain this one, declare that this nature is also a suit in the nature of civil nature. Suppose he is raising this issue now today. I'll pronounce a judgment. Suppose my judgment is in Mr. Chakraborty's favor that yes, this is also a suit in the of civil nature. Meaning thereby, I am opening out an alternative remedy. Tomorrow, anybody files a writ petition, Madam Fukan will take the objection, showing my judgment. He has an alternative remedy. He can go to a suit. High Court has held it.
So far as lordship, by the picture,
Number one. And number two, this being a good efficacious remedy in the administrative law available, as this is an administrative act. Either it is legal or illegal, we don't know. A government authority, administrative authority coming and digging somebody's private land is an administrative action which is contrary to the law. So, writ remedy is available.
it is available.
So, when writ remedy in the nature of is not only available but strongly advocated and followed, will it be in the nature of an implied bar? Can you give a meaning to the expression implied bar? So if it is an implied bar, civil suit they'll not entertain this kind of thing. Go to the appropriate forum. Or else this man could have easily filed an application, but DC, please stop this digging. This is my land. And if DC doesn't do anything, come to the REIT, immediately you will get the order to pass a urgent order on that application.
No, yeah,
And these are cases of not suits of civil nature, but cases where a legal right has been violated. And when legal right is violated, it is 226. See the language of 226. It's a serious question, Mr.
yeah.
So we like to have your services in this. Oh. Statistics. For the enforcement of any right conferred under Part 2, for the 226 is for enforcement any of the rights under Part 2, that is fundamental rights. This may be a case of Article 14 also, it's an arbitrary action. Anybody coming and digging anybody's land. Or for any other purpose, which is interpreted by the Supreme Court to be any legal right. So when a jurisdiction is given by the Constitution, will that jurisdiction not be in the nature of an implied bar? Otherwise, suits are misused. What happens, I'm telling you. If the dispute arises in either Barak Valley or places like Dhubri or a far off place, the lawyer will say, instead of going to Guwahati and taking all these things, I will give you the remedy here only. Go and file a suit.
It has happened. In fact, I personally have come across
It's happening.
service matters being dealt with
Therefore,
by
and I'm a little concerned about one example I gave you. The man died ultimately. He did not get anything out of this venture.
I remember I appeared in a case where Mr. S.P. Roy was the counsel for the plaintiff. Person was to retire tomorrow, but today he took an
Comes for a suit and say injunction against my thing.
He got an injunction. And thereafter I received and I had a officer said, you cannot go beyond the service book so far as the case is not be an injunction.
Over. Volume 1. Has the Supreme Court looked into this question anywhere?
There are some judgments on the powers of the civil. There are some judgments.
But don't you think something is required to be done?
Let me consult the. I have this matter, this issue.
Mr. Chakravarti, it may go a little against you, but for the broader interest, I think we better. Maybe we'll give you liberty to come. That will always be there.
As an officer of the court, I'll always.
You just see the fate. Ultimately, some of the litigants, when it happens, they don't realize.
I was about to point out to your lordship that had it been a dispute, the private part also involving government officials.
Then it's okay, because one right between the parties has to be determined.
But here, nobody, no private individual is clouding the right of this my plan.
Yeah.
The only thing that he is agreed with is the digging of the pond by the PTP.
Yes.
Now, as your lordship has rightly pointed out, that it's an administrative action against which remedies are available. Now, at best, my lord, these are off the record, whatever I have.
So, therefore, will it not be in the nature of an implied bar?
My lord, but at the same time, if I am to, my lord, support the case of my client, the only submission that I may, my lord, make here is that here, since there is a question of the part
No, no. That will be not even required to be decided.
My lord.
It is your claim, my land. Approach the 226 court or an application to the deputy commissioner. This is my land, please stop the digging.
And verify it by way of.
You cannot do, you verify the factual
Yes,
aspect.
then
If not, if the deputy commissioner says, say, suppose no, this is not your land, this is government land, then there may be a case of a dispute between the government and, or that possibility is there because the government is claiming ownership, whereas you are claiming
But no
ownership.
such verdict has fallen from any administrative authority.
Just digging. So every digging is interfered. I don't know. Just think about it. And this is digging, okay, to some extent, land is involved, a little bit of civil dispute element may be there. What about that promotion matter, that appointment matter I'm referring?
That today that matter that was.
One was appointment matter. Sometime back,
10 years.
10 years man is selected for appointment, somebody filed a civil suit, injunction, this, that, appeal, now in the second appeal or something. Second appeal is going on in that.
Yes, that I have read in my lord, again off the record.
Yes, please continue.
I just had a talk with the digging lawyer out there,
Mhm.
the lawyer, and he said that I have to prove my deed, whatever title I have to prove it. So I did not approach Mr. 26.
So,
I said that.
so that means a man seeking promotion will go to a civil suit, prove his appointment letter, prove his appointment letter. So, therefore, 226 is called a court of writ, a court of record. If the records reveal, you don't have to prove.
And there is no one coming to dispute on a private capacity. a
Definitely.
private-
So why should you prove everything? This morning I dealt with a matter, a registered document, court is disputing state, the vendor will have to come and verify. The concept of verification has gone to such an extent that everything has to be verified. The next question will come to you that, are you breeding? The witness says, yes, you verify and prove it that you are breeding. It will go to that extent if you keep on expanding these things beyond the necessary. The other lawyer will put a question to the witness. Are you in a proper state of mind? He'll say yes. Next, he said your proper state of mind. Now let him prove it now. Bring witness and prove that the man is in a proper state of mind. This is not civil law. Again, in one Punjab and Haryana High Court, the jurisdiction of civil court was not barred from entertaining the suit for permanent injunction, since there was no evidence on record of the case which the state produced that the property in dispute had been declared evacuee property. First suit, entertain, give it. Only then the question will come whether the defendants have proved it to be evacuee property or not. But is the question not to be gone into at the very beginning? it means it's again hit by the principle that you cannot make out a case on the omission or commission of the defendant. You have to prove yourself. Please see, if your submission is we are not required to go into his question, we'll not go into it. But otherwise,
As of now, it will also be a time.
because I felt for that man, second April, who died, claiming promotion about 25 to 30 years back in a civil suit.
Heartland districts. That is normally the court they take.
See, nowadays everything is so open. We have video facility, we have online facility. If we are also to the extent necessary that the man did not come out of his place, virtual method, you contact the lawyer, e-filing is there, everything is there. Or if you have too much faith of a local lawyer, not on the Guwahati lawyers, get it done through a local lawyer, let him argue.
These facilities are not calculated.
No, it is there. It is.
The infrastructure is there. The mind is not.
Mind is not there.
And what happens is it will take the initial rejection of state or not.
But debt recovery, the jurisdiction has been taken out by an express provision in the Surface Act. But there are many cases where there are no express provision of taking out. But possibly that's why I'm saying, can we give a meaning to the expression impliedly? Express bar is no difficulty. Quote the section, jurisdiction out. What about implied? Then why is the 226 there for?
Absolutely correct. They have approved the deputy commission.
Straight away.
Thereafter, if the order would have been against them, I mean, like
Suppose,
they could have covered.
suppose the municipality is constructing a drain in front of your house. Rightly or wrongly, they break down your wall. What will you do?
There is an appellate, there is an authority taken, then there is an appellate.
Will you not straight away go to that authority that you are doing an illegal administrative act in doing it? And digging a pond and breaking your wall and coming a few inches beside, both are same thing. Now, that's every time. It's an academic discussion anyway. By filing a suit, are you not doing a disservice? Because now the state will be at liberty to contest your title over the land, which otherwise possibly there was a presumption in favor of your title. You yourself is exposing to a situation where now somebody will question your title again. Whereas the situation is possibly for the video and all that your title was already established. Just think over. And if you make an application, you can compel the BDO or the DC to pass an administrative order,
After inspection or after verification.
either accepting or rejecting your claim. It will be very easy for you to challenge that.
That would have been it pay out. But they have it did pay and now the obligation is over. And I am in a catch-22 situation. The owner of the ship of my client, I cannot ethically say what it is. But the time the not yet. Yes, not yet. Not yet. That the business.
Again, keeping in the back of your mind that promotion man, who whole life must have dreamt about he'll get promotion. I have gone to the court with a civil suit.
The broader part of the matter is something that you're not here, but if we confine it, that of course has a different section. That's the restriction.
So, revision judiciary, we can
But
pass
my-
appropriate order.
Yes, but
No
on the
difficulty.
broader aspect, my lord has rightly
Again, for Mr. Mojumdar, Madam Fukan has already raised a complication. DC says I have no objection. BDO says no, I am pursuing with my petition, revision petition. She's called by her own instruction. She says no, I have no brief to go along with the petitioner. Come back. It's an interesting.